We're live, everybody. Hello, hello, hello. See if anybody comes in. I know guys just got done with court, hustled home, and we are here now. Videos, community. All right, let's see if this works. Busted Knuckles second. Hey, you got bust. Hey, Grayson being first. Oh wow. Late and gay court started at 9:30. Yeah, well, I got something late and gay for you. Actually, no, I don't. That'd be bad. Anyways, guys, yes, this should be good. Capisi saying letting him back in court is going to be a huge mistake. Probably will be, but she has to let him back in. Also, are they just on mute? Oh, yes, they are. Darrell looking very perplexed. Yes. So we are set for the closing arguments. Yes, Kevin McCauley, just let the hand waving begin. Oh, I'm sure it's going to begin. I'm sure this is going to be epic. Yes, we're not going to talk about what Judge Mommy wants. She is a good, wholesome woman who's trying. A good, God-fearing Wisconsin woman, don't you know? Message to live chats. Yes, Tuesday, Wisconsin 10. Yes. Okay, hilarious. Yes, Daryl's going to start waving his hands like he's guiding in the airplanes at the airport. Darcy, ooh, we just had a 5.1 earthquake here. I forget. Yeah, hope that's okay. Who will be muted first during closing, Brooks or me? You know, like I said, we're friends like you, Matt. Who needs trolls like Monty? Beauty in her brain. Thought it was done for the day. No, they got done with the jury instruction parts. Now we're to most of the jury instructions. Now we're to the closing. The state goes, Darrell goes, the state gets a rebuttal. And I talked about this last night. They have the burden of persuasion and the burden of proof. So they get to go again at the end. And then the judge has some more instructions. And then they'll be done. So they're probably like, it looks like we'll be done around 5:30 or so. And then the jury's going to be sequestered. And maybe they start deliberating tonight. It's going to be up to them. I mean, I think they're going to be out probably no more than 2.5, 3 hours, just solely to go through, to give everything a once over and to go through all the documents. It's going to take a little while. So we will see, though. Time will tell. Oh, here we go.
That's from yesterday too. You gotta scan that in too. Okay.
I'm sure we're not going to address subject matter jurisdiction again. This court's going to ignore it.
The yellows.
This brave free man traveling the land.
Yes.
The brave escape captain.
This Is there a fourth one? There's one on your, I bet on your.
We'll get to this, James. There you go, Matt. I boomered it. There. I muted.
All right, it's 2:00. I'll call the case. State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. May I have the appearances, please.
Good afternoon, Judge Slapper, Leslie Daisy, and Zach Wichow appearing for the state.
I'm here without prejudice by special appearance. Beneficiary, I'm here under fraud, menace, duress, and extortion. Judiciary, Jennifer R. Darrell. This is a social security cestQ trust action, which you are.
Oh, we're getting the good sovereign citizen stuff now. The trust
and propria persona. This is a military admiralty tribunal and maritime law. And the Title 4 of the United States Code, Section 1, which you can see, which states placing of fringe on a national flag is within discretion of president acting as commander-in-chief of the Army and Navy.
You finally did it.
A common law court or an admiralty court?
This is like Sovereign Citizen 101, guys. This is like Dale Gribble stuff.
The individual known to this court as Darrell Brooks is present in person in custody. He is wearing a dress shirt. I know he has a suit coat, but it's not on. He's also wearing a mask. The court is not going to address any of the issues that he is raising, as they are meritless.
Because of bullshit.
I would also say the same as to the notes that he passed while he was in the other courtroom. For the record, I did provide a copy of all of those to the state as well. They are also uploaded into the file and are made part of the record. To the extent that he raises objections or lack of consent, it is noted for the record.
I was about to do that and say that I don't consent to being called that name or identity. That is the trust name, and it is not me, myself. I don't recognize that name, nor do I consent to being called by that name. With all respect, Your Honor. And we still have yet to address subject matter jurisdiction, which has yet to be proven on the record. May I receive those original copies time-stamped?
Okay. All right, I need to make a record of one part of a jury instruction that I do need to advise the jury. It will also be corrected in the packet. I believe within the last year, the jury instruction on credibility of witnesses was modified by the jury instruction committee, and it was just an oversight on the court's part to not include, it's really just one paragraph. It was read to the jury at the beginning of the case with the preliminary instructions, but it is a paragraph regarding implicit bias. And so I do think it's important to advise the jury of that. I intend to do that when they come out. And then again, the full instruction will be amended so that it's in the packet that goes to the jury. And Madam Clerk, if you haven't already, if you could print off page 72. It's the, it adds a paragraph before the last paragraph that starts with, "There is no magic way for you to evaluate the testimony." And again, I wanted to be consistent with the most recent version of the jury instructions and consistent with what was instructed or provided to the jurors at the beginning of the case. And so I will make sure that they have that and so advise them when they come out. Also, I will read instruction 160, closing arguments. Madam Clerk, if you could just make the change so that it's of parties. We've missed that correction as well. So it's the closing arguments of the parties, not the attorneys. And so I will just make that correction and make sure it's.
I accept the value in return for value of this document. And Your Honor, I requested that I have copies of my filings from earlier, time-stamped.
Mr. Brooks, I'll provide you with the copies later on. I need to continue with the instructing of the jury and have the parties make their closing arguments.
Your Honor, with
I
all
did-
respect, the state received copies. How come I can't receive the copies of my filings?
You know what? I can give you the print offs, but I can't give you the originals right now. That's what I'm referring to, and you will absolutely get those back. I guess I was mistaken that you wrote copy on it. I thought you retained a copy for your records. So with that, Madam Clerk will print off from the record. It won't be the yellow copies just yet. I'll take that up later outside the presence of the jury after the case has been given to them. Now, in terms of the closing arguments, I did set a time limit for the parties yesterday. Each side will have a total of 1 hour. Mr. Brooks, so that you are fully aware, the party with the burden of proof, which is the state of Wisconsin, goes first. Then you, as the opposing party, will have an opportunity to respond and argue. And then, time limit willing, the state also has the opportunity to present rebuttal because they have the burden of proof. And that is provided with the excerpt from the bench book that was provided to you yesterday. It has the purpose of the closing arguments is to summarize the facts, marshal arguments, focus the issues for the jury. I just talked about the order of the arguments. The scope of the arguments are the content, duration, and form of argument are within the court's discretion. That's why I set a time limit of 1 hour for the parties. And Mr. Brooks, I will advise you that I
Thanks for
certainly
stopping in,
will wait
Watcher.
and see how you present your argument today. I will certainly wait to see if there are any objections raised, but I also want you to be aware that if I feel the arguments are improper, I may simply, without an objection, say, please move on, as a clear indication from this court that what you are stating is not proper under the
Let's be real. We know what's
various
going to
rules
happen.
and case law that govern closing arguments.
Again, Your Honor, without prejudice, I'm here by special appearance. I don't consent to being called that name for the record.
It's noted, sir. All right, then with that, I will have the go ahead. Looks like Attorney Upper has some issues she wants to raise.
Yes, I just have one question, Your Honor. Would I have permission to put the easel up and display some of the poster boards? I did confer with Captain Dussault as far as security is concerned, and he agreed to it if the court would give me that authority.
Where would it be displayed?
It's gonna put it like right here, and then you want me standing at this table during.
I do.
Yes, so I would just position it like right here.
Um,
And I don't have to leave it up through the whole thing. I realize it blocks the view of people in the courtroom. Detective Casey would be willing to assist me in removing them when I'm done with them, if that's okay with you.
I trust it won't block Mr. Brooks' view of the jury, and
That's
as long as
yeah, I was gonna put it like right about here so that he could still see me and the jury.
with that caveat, yes, I will allow that.
All right.
Objection, what is that? What is supposed to be put up?
They were previously admitted, Your Honor, it's exhibit 15 and 130, I believe.
So are they exhibits? I'm confused to what they are.
Mr. Brooks, I've made a ruling. The state has made a request. I've granted it.
Yeah, but
In
I'm
terms
saying,
of,
I don't understand what's being shown. Should not have the right to ask, to object and ask what.
You do have
is
the
that's
right.
actually gonna be shown.
the state's put on the record what it is. They are exhibits that have previously been received by the court during the course of this trial.
Perfectly
That
acceptable.
is proper for a party to do that during its closing arguments.
So can I put up exhibits?
Mr. Brooks, I don't know what you have planned for your closing argument. So,
I'm making a request, the same request. May I be able to put up,
well, I guess it
exhibits?
depends on what it is, sir. So I'm not going to take up any more time because what I intend to do is, once the state.
You didn't
goes
even
through
prepare,
its
Darrell. You have no
closing,
idea
I may
what you're
take
putting
just
up.
a short comfort break, depending on how long it is. And if there's something in particular, what are you will need to tell me what it is. As long as it's an exhibit from of exhibits that the state wouldn't have, that you would have. Everything that's been received, we have a list. So if it's not something that was received during this trial as an exhibit by the court, unless you tell me what it is so that I can make a ruling, I can't see how it would be relevant or appropriate for your closing argument.
They're part of my filings that you filed.
The filings have no relevance to the issues that are before the jury. The closing arguments are to
Those
direct
are
the
not.
jury
Those don't count,
so
buddy.
that they have your arguments, so that when they go back to determine the issues in this case, which are related to whether you're guilty or not guilty of the 76 charges, things like subject matter jurisdiction or like that would not be something that would be proper before this jury. Those are legal issues that the court would decide. The jury is the judge of the facts. The court is the judge of the law. That's why I have all of these jury instructions to give to the jury.
I'm not referring to subject matter jurisdiction.
What are you referring to then? Be very specific so I can make a finding. In
Yes,
I was
very
specific.
specific.
My other filings that
That's
was
not
filed.
specific enough, sir. What are you
My
referring to?
court docket
Which
sheet,
filing?
Let me know when you're done, Your Honor.
Which filing, sir? Not generally, but specifically.
Are you done?
Uh-oh, he broke the feed.
Are you done?
Sir, that's very rude and
No,
disrespectful.
I didn't know if you was finna say something.
I
That's why I'm
paused.
asking, are you done?
What filing
Your Honor,
are
how
you
come
referring
every
to?
time I try,
Get
even
it,
when I
son.
try to err on the side of caution, you find some way to make it to be something that it's not? I didn't know if you was gonna say something else.
I've asked a question, sir, so
Fight the power,
when I do
Darrell.
that, I would hope it would convey to you I'm looking for an answer. So which filing are you referring to?
All my
specificity.
filings, my notice of appearance, my statement of particulars, my bond, the court docket sheet,
The docket sheets.
all of those filings.
The request to display those to the jury is denied. It's not relevant.
How is it not relevant? Not even your
That's my
oath of office?
determination, sir. So I am going to start this.
Not even your oath of office can be shown?
No, that is not relevant to these proceedings, sir.
It is.
It's not relevant in front of the jury.
Why is it not relevant? Can you
Mr. Brooks,
you
you
explain
are
why
not
that's
going
not
to be
relevant?
able to
This is
raise
beautiful.
those types of issues and present a closing argument based upon
We're gonna miss
my
him when
oath
he's
of
gone.
office, whether I'm licensed to practice law in the state of Wisconsin,
I said your oath
whether
of
there's
office.
subject
I didn't
matter
say anything.
jurisdiction, whether you consent to this appearance or not. None of those things help the jury determine the issues in this case, which are related to whether you are guilty or not guilty of the 76 charges that have
The
been
jury
filed
should
in
know
this
that
case.
they should know the truth in their duties, in their rights. They should know that at least.
Mr. Brooks, I'm putting you on notice that if you
You can
continue
get yours
with
down below at the
this,
link.
insistence upon presenting information that's not properly before the jury as evidence in this case, that I will instruct you during your closing argument to move on and potentially ask the jury, have the jury leave so that I can admonish you. And if you keep insisting on that, sir, that will be in direct violation of the court's direction
So
to
they
you.
can't even know that I got a
No.
shock device on my ankles.
They absolutely do not.
Why would
need
you want them to
that.
know
It's
that?
not relevant to the determinations of guilt or innocence in this
It's the
case.
truth.
Why would you want them to know?
Mr. Brooks, your custodial status is not on trial here.
I will
No,
argue that it
your
is.
conduct from November 21st of 2021 is what
That
is
hasn't
on
been
trial.
proven.
You may not bring up the way that you've been shackled. It's not relevant, sir.
It's
and if
the
you
truth.
do so, you do it at your peril. But here's the
There
thing:
is
the
no
jury
peril.
is specific.
It's my right,
No,
though.
let me go. Okay.
Let
It's
me
my
go.
constitutional
is-
right. Just
There
like
are
under the
certain
First
things
Amendment,
that
which I
your-
preserved my First Amendment right when I came in this morning, I also preserved my
Right.
Sixth
Mr. Brooks.
Amendment right.
Please stop. You do not have an unfettered First Amendment right. That is very clear based upon.
What do you
all
mean
the
by
case law.
unfettered? What do you mean by unfettered?
It
I
means
don't.
it is not absolute. It
No,
should
the
be
court reporter
restricted.
types as
So
is.
the Constitution of the United States can be constricted.
All right. Mr. Brooks, I'm putting you on notice that if you continue with your insistence on raising issues that are
I'm going to
merely a
raise issues that the jury needs
that
to
are-
know,
they're not
regardless,
issues.
because they're under the rights of the United States Constitution, which
Mr.
is the
Brooks,
law
I
of the
direct
land.
your attention to closing instruction 460.
I'm
which will be
going
read
to
jury
let the
at some
jury
point.
know the truth, their duty and their rights under the First Amendment and under the Sixth Amendment. I have the right to inform them of their rights, of the truth, and of their duties under the First Amendment and under the Sixth Amendment of the Constitution of these United States. You can't, no state law can override that.
Mr.
Any
Brooks,
law-
do you intend
any
to
law
keep this up when the
repugnant-
jury comes out?
Your Honor.
Because I need to
No, I
have
do
the
not. That's
state-
why I'm addressing this before
not-
they come out. That's why I'm trying to address this before they come out, so it doesn't become an issue once they're in here. But under the First Amendment and under the Sixth Amendment of the Constitution, which are rights that I preserved the moment we stepped in here this morning when this proceedings started, I preserved those rights for the record. And now you're telling me that those rights are not, would you say unfettered or I don't know what you say. I don't even know what that means. I don't even understand that. But any law repugnant of the United States
A
Constitution
lot of words
is
you don't
null and
understand,
void.
Darrell. Most of them.
Mr. Brooks, I'm putting you on notice that you can also forfeit by your conduct the right to present a closing argument. In appropriate circumstances, the right to present a closing argument, no different than the right to testify, may be subject to forfeiture where your conduct is incompatible with the assertion of the right at issue. The goals that this court has attempted to follow throughout this proceeding are multifaceted and multifold. Number one, I do have an obligation and I have
facet?
done my best to ensure that this is a fair trial. However, a fair trial does not mean a defendant has unfettered rights to state whatever he wants when he wants. This court, not only through the course of the trial, is deemed with the responsibility to control the presentation of evidence as to ensure fairness and reliability of the criminal trial process. It also includes ensuring that the closing arguments are relevant, are appropriate. This court must also be concerned with efficiency and effectiveness, and of course, last but not least, courtesy and decorum in this courtroom, what I would generally refer to as civility in the courtroom. You do not have unfettered First Amendment rights or an unfettered Sixth Amendment right, sir. You must conform your conduct to the rules of decorum, the rules of evidence, and the rules of procedure. While you have a right to present relevant and probative arguments to this jury, you may not present arguments related to such things as jury nullification, subject matter jurisdiction, the court's oath or lack thereof, if that's what you believe, whether this court is a court of common law, admiralty, all of those things relate to your claim as being a sovereign, which are frankly baseless. They're meritless. They've been debunked by many courts, including the court in the Venloughby decision that's been referenced by this court previously. I will give you a fair opportunity to present a closing argument, but again, it is not unfettered. The simple fact is, sir, this court can restrict your right to present a closing argument. This court has the authority under 906.11, under the various cases, including Illinois versus Allen, including Rock versus Arkansas, although Rock versus Arkansas and Chambers versus Mississippi dealt with the right to testify. There is a decision, I looked it up earlier, and I'll just pull it up and tell you the case site so that you have it. I would direct your
So
attention
did Arkansas
to Herring
prosecute
versus
a
New
rock
York, found
or
at
the rock?
422
I'm a little
U.S.
confused with that one.
853, a 1975 case, although in a footnote, It does stand
Herring
for the
versus New
proposition
York.
that a defendant who has exercised the right to conduct his own defense has, of course, the same right to make a closing argument. That's quoting state Ferretta versus California, or following the same logic from Rock and Anthony and Chambers, a right, even a constitutional right that a defendant has may be forfeited by conduct. This court, just like it attempted to do with regard to your right to testify and set up reasonable restrictions so as to meet all of the goals that the court needs to meet, will be as follows, and that is, again, sir, you may not bring up matters that are not relevant to the determination of guilt or innocence. That means evidence that was not presented and not received in this courtroom is not relevant to your closing arguments. It's not, the arguments must be based on the law, not as you interpret the law, but as the law is. You must base your closing arguments on the facts that have been established during this case, meaning the evidence, the testimony. As I indicated earlier, the purpose of a closing argument is to summarize the facts, marshal arguments, and focus the issues for the jury. It is fair that you comment on evidence, including arguing evidence to the conclusion or inference. It is your ability or your opportunity to convince the jury that you are not guilty of these offenses. You may not convey any idea that you have undisclosed information. Neither party may vouch for a witness or otherwise express personal belief or opinion regarding truth or falsity of any testimony or evidence. It would be improper to ask a jury to draw inferences that the parties know are not true. And your comments on evidence is limited to evidence in the case. You may not comment on facts outside the record or peculiarly within your own knowledge. And that is just some of the guidelines for determining the proprietary of arguments that I am guided by from my judicial bench.
Those guide all closing arguments, by the way.
That are referenced therein.
All closing arguments.
So
yes, T-Dog, he's going to do
sir, that
yes.
even without an objection, this court may, in an effort to preserve the dignity, the decorum, and to keep the issues properly before the jury, may advise you during your closing argument to move on. If you do not honor the court's rulings, then you will run the risk of forfeiting your right to be present and potentially forfeiting your right to further present your closing argument. With that, I am bringing this jury out to complete the instructions that I need to complete, to add to the credibility instruction, the paragraph on implicit bias, and to let them know the full instructions that they receive will have it, to read 160 closing arguments of the parties, and then to have the state go first as they bear the burden of proof.
Now, Your Honor, I'll just let you make your
Yes,
record.
T-Dog, he thinks this is like an objective
interrupt.
list.
Is that fair to say? I'll let you make the record. With all due respect, when will I be able to make the record? As I've tried to do numerous times by saying I wanted to present an offer of proof for my appeal. That's the chance for me to be able to make the record.
I'm denying your request to make an offer of proof regarding your appeal. It's
So
not, I am
I'm
not
not allowed to
required
make the
to give
record
you that
at all, Your Honor?
opportunity, sir.
I'm not allowed
Sir.
to make the record at all.
You could do proffers.
As I
It's
just
too
let
late
you
now.
did because some of the
Sir,
issues
I
has
have-
been
A proffer.
Some
You
of the
have
issues
told me
has
what
been-
you want to do.
Your
I've told
Honor.
you you can't. I've addressed
Your
the
Honor,
request.
some of the issues have been me over talking you and interrupting you. I did not do that. Even though everything that you said, you have not proven for the record and it's unlawful law. You haven't shown one time that is lawful for you to do what you been doing as
Mr.
far
Brooks,
as your rulings.
once again, I'm not going to debate with you the prior rulings of this court. There's absolutely no need at this point for you to
Your
make an
Honor.
offer of proof regarding my prior rulings or decisions that you disagree with.
Your Honor,
You
I'm
will have
going
an
to
opportunity,
inform.
if
I'm going
convicted,
to
to
inform the
raise
jury.
every issue you want on appeal.
I'm going to inform the jury of
Yeah.
the truth, their duties, and their rights, as I have the right to do under the First Amendment and under the Sixth Amendment. You can't just disregard the United States Constitution. You can't do that. Again, any law repugnant of the United States Constitution is null and void. There's no state law that you can cite. There's no federal law that you can cite that overrides the United States Constitution. You
Mr.
know
Brooks, I
this.
direct your attention to State versus Anthony. Although that case dealt with the right to testify,
Okay, so
its
we're not
reasoning
talking about
is
the right to
equally
testify.
applicable.
We're talking about the closing arguments, correct? We're not talking about testifying, which you
Mr.
already
Brooks,
made a
I'm not
ruling
going
on.
to delay
You
any
already
further
made a
the
ruling
closing
on.
arguments
But
of
Your
the
Honor,
parties.
with all due
I will
respect,
address your further request
with all due
once the
respect,
state.
you already made a ruling about testifying. Did you or did you not?
Mr. Brooks,
So we're talking about now. We're talking about closing arguments that I said
It's their bread and
it's
butter.
my right to be able to inform the jury of the truth, their duties, and their rights. That is my constitutional right.
Mr. Brooks,
You
we are
can't
at the stage
tell
of
me
the
I can't-
proceedings where it is the state's burden of proof where they get to make their closing argument.
We're talking
first.
about me, though.
I understand that, sir, but
I'm going to inform
your
them of the
conduct
truth.
right now is delaying
The truth.
I'm not intended.
the court's
to delay
intention
anything.
of moving
I'll let
forward
you-
with
Your
the
Honor,
closing argument.
I just
True.
sat there and let you make the record. I didn't overtalk you or interrupt
Tack
you.
it.
I let you
Get her.
say what you wanted
Get
to
her,
say.
Darrell. Be tacking about
I
it.
let you make the record.
He tacketly.
I didn't interrupt you not one time.
Yes,
No,
for the
but, sir,
first
you're
time.
Attempting to disrupt the proceedings by
I'm
going
not
off on a
attempting to
tangent
disrupt
into
anything.
all of these other issues.
How-
From my
how am I-
perspective,
I'm a
that
good
is
boy.
in
I
an
How am I
attempt
being
nothing.
to
dishonored?
simply
How am I being
delay
in
what we're
dishonor?
doing.
How am
So
I being
you are
in
put on
dishonor?
notice. I am done dealing
How
with
am I
these
being in dishonor,
issues.
Your Honor? How am I being in dishonor of the court?
Mr. Brooks, I've made my determination.
And have
I'm
I not
going to
preserved my
address
rights?
this further.
Have I not preserved my rights?
If you insist on interrupting the court and disrupting the flow of these proceedings by a blatant disregard for the parameters that I've set up, you will forfeit your right to be present in this courtroom and potentially forfeit your right to present
I'm gonna need a bunch of
closing
white
argument.
claws.
Under
this
what
one,
lawful
guys.
law can you do that?
Sir, I've
You
made
can
my
hold me in
determination.
contempt by Illinois versus Allen. You can do that.
It's not a contempt issue.
You
Darrell.
stated that numerous times.
Mr. Brooks, I want you here for the closing arguments, but
Apparently
you
you
do
don't.
not want
Apparently
to
you
follow
don't, Your
the
Honor,
rules.
Here.
because all I
Aw.
said was it is my right under the First Amendment
He's
and the
so
Sixth
sweet.
Amendment to inform the jury of the truth, their rights, and their duties. I never once said anything about, oh, I'm going to bring up subject matter, or I'm going to bring
You're
up
right,
this,
sir,
or
and
I'm
I
going to
will
bring
wait
up
and
that.
see what you have to say. But I thought it prudent, given your conduct to date and your insistence on bringing up issues that have no bearing in this case.
This is a new
They're not
day, though, Your
relevant.
Honor. This
They're
is a
not-
whole new day.
That it was prudent on my part to give you some guidance before you potentially do that in front of the jury. But
Okay,
you're right.
but-
I will wait and see.
Your Honor, it's
But I
still
need to get going.
it's still
and I'm going to,
unconstitutional for
sir.
you to
So
tell me that
You
I don't
need to
have
be
the First
quiet.
Amendment right that I preserved, or the Sixth
Mr.
Amendment
Brooks,
right
I'm
that I
going to have
preserved,
the jury brought out. I expect that you will be respectful, courteous, and quiet.
or I'll be
And
held
when
in
this door
contempt,
opens,
or I'll be held in
if
contempt.
you insist on making remarks, then I will excuse everyone from this courtroom and you will be removed because you will forfeit your right to be present for being disruptive.
Under what lawful law?
That
Because
is
I
my
haven't been
ruling.
dishonorable to the court.
Madam Clerk, please have the jury brought out.
Well, take me to the next courtroom then. Take me to the next courtroom, because you're not going to override my constitutional rights just because you feel like you can, and you don't have no lawful law to do that. We all have constitutional rights, and you cannot trample
Mr.
on
Brooks,
those.
what you are raising are essentially issues that you can raise
gonna
on
give up
appeal.
No, I'm
right
raising them now because they need to
automatically,
be on the
though.
record
Why
now.
don't you do that?
Because you won't allow me to make the record as I've let you do. You've even went so far as to mute
Mr.
me,
Brooks, the
which you
jury
can't
is
even.
coming
There's no
out.
lawful law to say that you
I'm
can even
advising
mute me.
you to be quiet. They're coming
Your Honor,
out.
does Illinois versus Allen say that you can utilize the mute button? It does not.
Yes.
Mr. Brooks,
So
when
you're-
the door
you're-
opens, I expect you to be quiet.
You're,
and you will
you're,
forfeit
and I
your right
expect
to
for
be
you
present.
I expect for you to answer questions as a public servant, Your Honor.
Oh.
You're a public
The
servant.
jury's coming
You're
in.
supposed to serve the people.
All right.
Take me to the next courtroom. Please, take me to the next courtroom.
Oh my God.
Hold me in contempt. Hold me in contempt. Hold me in contempt.
Hold me. Hold me.
Hold me in contempt.
Never let me go.
I have
not
constitutional
what he's
rights that are
talking
being
about.
trampled on, and you're coming up with ways to make a lawful law where it doesn't say in Illinois versus Allen anywhere about utilizing the
Records
mute button.
reflect that the jury
The
bailiff
record
is
should
in
reflect
here.
it's
However, the jury is
Illinois,
still in the
not
hallway.
Illinois.
I'm going to give Mr. Brooks one more opportunity to be respectful of the court's rulings,
Your
whether
Honor,
he
I
agrees with them
I
or
haven't
not.
dishonored the court.
French.
I'm merely exercising my rights under the Constitution, under the First Amendment, and under the Sixth Amendment.
Mr. Brooks, your rights do not include you disrupting these proceedings
I'm
the way
not
that you have
disrupting
through
the
the course
proceedings.
of
You just
3
told me
weeks.
you don't have to honor my constitutional rights in so many words. You're using a mute button
Mr.
that's
Brooks,
not
the
even in your
jury is
decision.
outside this door. They're not brought in
I'm
yet.
informed that
I'm
the jury. I'm
asking
informed
you
that the jury
To
is
be
outside the
respectful
door.
of their time.
They're not in the courtroom.
I'm
They're not
asking you to
present.
be respectful of the court's ruling,
They're
whether
not
you
present.
agree with
These
it
are
or
issues
not.
that need to be resolved before they're present.
Mr. Brooks, they will not be resolved to your satisfaction.
It's not about my
The
satisfaction.
record
It's
has
about the
been made.
Constitution. It's about what's right.
Are you going to?
He
Are
demands
you going to
follow the
answer
satisfaction.
questions as a public
requirement?
servant on why you're making up laws that are not in the Illinois versus Allen and never utilized
the
the
jury
mute button?
can
It
go
never
back
said
to the
anything
jury
about a
room.
mute button.
It is clear
Why
that
am I
Mr.
being
Brooks has
muted?
absolutely
That
no
you-
intention of following the simple rules of decorum and courtesy. He has repeatedly talked over me. He's repeatedly interrupted. Even though I've made rulings, he's not respectful of the fact that I made a ruling, even though he disagrees with it.
How can you
I
make
attempted
it?
to bring the jury out.
How can you
and
utilize a mute
He
button?
continued to talk.
That's
So, Mr. Brooks, you
Your
have
Honor,
forfeited your right to
is
be
that-
present for the state's
is that
closing
not,
argument.
Your Honor?
You will
Can
be
you answer
taken
this
to
question?
the courtroom next
As a
door, and I
public
will
servant-
invite you back over when it's time for your
You can't
closing
invite me
arguments.
back over. I can reclaim my right. So how can you invite me
All
to
right,
do
the
anything?
courtroom is to
Put
be
back
cleared
clock
so
back,
that
Darrell.
Mr. Brooks
You
can be
man.
moved to the next courtroom, and I'll make appropriate findings when
Assert
he's
your
in
right.
the other
Yeah,
courtroom when I
and
can
you'll
do
mute
so
me, which you
without
can't lawfully do.
interruption.
You can't lawfully mute me. So now you're trampling
She's
over
definitely
my
going to
first.
do it, even if she can't. Oh, and see, look, even Fox 9 is silencing the man. He's just trying to tell you what's up. Well, I guess we kind of expected this to happen. Not as good as yesterday, but he's getting there. He's getting there. So let's kind of see where we are. Just go back and kind of cover some things real quick. James Collier says if Brooks crossed out portions of the contract to waive his right to an attorney, does that mean anything? No. Now, that is in contract law. So, like, if you're out buying something from somebody else and you're both businesses and you're negotiating terms of a contract, this old school way of doing things was you would scribble out terms on a contract and people could initial it, and that would be considered an acceptable contract. If it was scribbled out and the other party didn't oppose it, it was considered removed from the contract as a term. Nowadays, that could still be the case, but what any attorney worth the salt will tell you is type up the forms and get it done right. But you could do that. So that's, once again, this is where they use these civil contract issues to try to screw with the system. President-elect Four Doors More Horse says Fort Grounds was breached within mere minutes of being manned. How long until Brooks's rear gate is breached after getting sent to prison? I don't know. Time will tell. Matt is saying, will the state be allowed rebuttal if Brooks does not close? No. If he does not have a closing argument, that's it. If he declines, then there's no closing argument. There's no rebuttal. If he does give a closing argument, though, and then she shuts him down partway through, yes, I would expect them to be able to rebut what he mentioned. So if he only gets a couple minutes in, they're going to be really limited in scope. Automata for $5. Thank you for the super chat. I appreciate it. He says, I like how the rebuttal is supposed to be limited to material covered by the defense, but in practice, they get a second closing as the Kim Potter trial. Well, that was... The judge sucked. Judge Chu was not a good judge. She should have done the right thing and prevented that from happening, but she didn't. A lot of courts would have stopped that, but that's, I think, when you have a weak bench, that causes that issue. And here, this is not a weak bench. This is a very well thought and strong bench. Ninja Bread Man says, how much do you want to bet the notes he sent her was an offer to suck her toes if he goes free? Funny. Nima says, yeah, I think I've seen you asking people to mass flag channels for no reason. Don't understand why. Never have done that and never will ever suggest that. That is a shitbag tactic, and whoever does it is a scumbag of the highest order. So I don't know where, I don't think you've ever seen me saying that, because if you have, use one of these, clean your glasses, or go see an optometrist. Mema X says she's absolutely dreading his closing argument. She's going to have to shut him down every 30 seconds till he ends up back in the cage. Yeah, I think she's worried about that. But she'll deal with it. Reality of a Second Life says Darrell Brooks reminds me of that person at the buffet line. Just getting everything because everyone else is getting it, then doesn't even eat it. Yeah, that very well could be him. Julie F says, what name does he want to be called if not his given name? I missed the early days of the trial. So there was one point where the judge said, okay, fine. What do you want to be called? And he said, I don't want to be called Darrell Brooks in all capital letters. The judge said, okay, we'll call you Darrell Brooks in lowercase letters. Will that work? And he said, no. So it doesn't really matter what he wants to be addressed as. This is all stall tactics. This is kind of the Princess and the Pea. There will never be good enough for him. He'll always want something else. Or it's like if you give a mouse a cookie, you can never satisfy him. And once you meet that, and once you acquiesce to that one thing, he's immediately going to jump to something else or say it's not good enough. Capisi says he wants a mistrial so badly he's going to say something to get it. No, I mean, the judge will do everything she can to prevent that from happening. He's not going to get it. And you inducing a mistrial generally doesn't get you a mistrial. So, Trot for hey, what's up, buddy? Says, Sean, can you admit the only sovereign citizens work for the government? Yes, in the sense that they operate outside the law and get to do what they want. Wholeheartedly agree. Yes. Yes, if only we all got qualified immunity. But that's another discussion for another day. Free Flyer 1978 is a new member. Thank you very much. I appreciate your support. Very, very much. Free Flyer 1978 for $5 as well. Thank you. Says sovereign citizens are sovereign until they are either bleeding on the side of the highway or wannabe clowns in court. Very true. Very true. Free Flyer 1978 again says for and thank you for $10, says, I wonder how the judge from Kenosha would have taken all this disruption. If he could chew out prosecutors, I'd imagine he would have torn Brooks apart. I've said this before. Judge Schroeder was a big old floppy pussy. If you know how to push his buttons, he was a teddy bear. And that's what Binger did. So Brooks would probably be able to push his buttons and he would get all, don't get brazen with me, but then nothing would happen. So no, and people like to say, Schroeder was an awful judge. Okay? He was an awful judge. And thank God he didn't have to make the decision to acquit Kyle despite a verdict, because I don't think he would have done it. He was an awful judge. The Pike case says, why are the jury instructions broken up by the closing arguments? Because there are instructions about you've now heard the closing arguments. You guys need to go back. You're going to pick your foreperson. Here's how you're going to deliberate. You can only deliberate when all of you are in the room together. If you have questions, ring for the bailiff. The bailiff will come back. You guys are not there are a couple of questions after there's a couple of instructions after the closing arguments. They have to be told what to do. So there are some rules. Now, there are some courts where I've been in front of where the judge does them all right at the beginning, and then the closing arguments happen, and that's it. I think a little bit of like 2 or 3 pages of just look here, knuckleheads, here's how you're going to do this, I think is fine. Remember, though, she just read like 100 some odd pages of stuff. So breaking this up would be a good idea. Common lawyer saying, why does he want to be held in contempt? Because he's an idiot. He thinks that's somehow going to help him on his appeals. Somehow vindicates him and is going to be his get out of jail free card. Corey Hartley from 199. Thank you very much. But Super Chat says, very interesting. Good commentary. Well, thank you. Monad says, is she going to entertain objections during the closing or just mute? Well, you do have the right to object during an opening or closing argument. You'd better... I've done it. You better be really sure you want to do it, because it is considered, absent a very grievous error on one party's part or another, you don't do it. Now, for example, I had a trial in May. Prosecutor made a couple references to my client's post-arrest silence.
I need it quiet in the
That's
courtroom,
prohibited.
please.
I immediately objected.
We are back on the record.
He made comments about what we did or did
Appearances
not
are as they
present. I
were before,
immediately
except
objected
that
because
Mr.
none of our
Brooks
burden
has
of proof.
been
It's very
removed to the other
delicate, but yes,
courtroom.
you can do it.
The court did that because
He has the
we
right to
came
object if they say
out
something proper.
on the record at 2:00 following the lunch break. Mr. Brooks was brought to the main courtroom. And during that almost 35 minutes or so, he was insistent on raising a variety of legal issues with which this court has either previously addressed or which are meritless and do not warrant any further response. He is insistent on making a record and an offer of proof. This would not be the appropriate procedural mechanism, meaning an offer of proof at this time. We are not in the midst of a trial where the court's made an evidentiary ruling that would require the preservation of the record by making an offer of proof. This court has been attempting, frankly, all day to get through the reading of jury instructions, to get to the point where the parties make their closing arguments, and ultimately to put this case in the jury's hands. It has been challenging. It has been met by resistance from Mr. Brooks. I would once again describe it as being stubbornly defiant, although at times he may wait for me to make my ruling. He continues to not respect the fact that a ruling has been made, and he wants to argue and re-argue and re-argue points that this court has already gone over. And in an effort to simply put him on notice regarding his behavior, given the history of this case, the court was attempting to set some parameters regarding closing arguments so that they are focused, so that they are proper, and that they follow the law.
Lawful.
That was met with a considerable amount of resistance and repeated statements by Mr. Brooks that he has First Amendment rights, Sixth Amendment rights, 14th Amendment rights. He has all of those rights. That is not in dispute, but those rights do not come in a vacuum when we are in a court proceeding, in a trial such as this. The rules of evidence, the rules of procedure, the rules of courtesy and decorum all apply. And this case has demonstrated that a stubbornly defiant defendant can forfeit even important constitutional rights by conduct. That includes the right to be present. It included the right to present further witnesses and testimony, and it included the right of the defendant to testify on his own behalf. I hope that I do not have to go through a decision that forfeits his right, or that makes a finding that he's forfeited his right to make a closing argument. I will certainly wait and see how that goes. I would note he was very respectful when he did his opening statement. It was clear. He made a variety of points. He did so in
None
a
of
way
which
that I
made
would say
sense.
was very conscientious of people's time. It was cogent. It was concise. It was probably about 35 minutes.
It was
I may be
awful.
off a little bit, but that's what my memory is. It wasn't overly lengthy. I would hope that he follows some of those same things
Yeah, all he
here
did was make
when
bad
he
points.
does his closing argument. But he has been removed from this courtroom because of his stubborn defiance and disrespect of this court, of courtesy and decorum. And what I truly believe is an effort on his part to continue to delay and lengthen these proceedings. I've said it before, I'll state it again. It is essential to the proper administration of criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings in our country. The flagrant disregard in the courtroom of elementary standards of proper conduct should not and cannot be
Oh, he's standing
tolerated.
up. That's
And
interesting.
trial courts and trial judges that are confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. They noted 3 constitutionally permissible ways to handle such a stubbornly defiant defendant. But they also indicated that no one formula for maintaining the appropriate court atmosphere will be best in all situations. I've noted this before. This is a case from 1970. The technology that we now have in this brand new courtroom was not available then. I have the ability to have Mr. Brooks appear from the other courtroom by way of audio
At
and
his summer
visual
home.
means. We can see him, he can see us. I've confirmed prior to calling the case that the audio was working, that the video is working. The one camera, there's 4 cameras in my courtroom, there's 4 cameras in his courtroom. However, it is set to 1 camera since he's the only individual there. Other than the bailiffs, but I'm talking about as a party to the litigation. So the courtroom, the cameras in my courtroom include one that would normally be on the witness stand that has been zoomed out so as to capture the large majority of the jury box. I even adjusted the camera that's on the state's table so that the exhibit that's currently up to my left, her right, Attorney Opper, is viewable in the camera angle. And she is still present within, meaning viewable within that as well. And although I've made a finding that he has forfeited his right to be present for the state's closing argument, I'll find that the technology that I have available, it is that his appearance from the other courtroom is the functional equivalent of appearing in this courtroom and being present due to the technology that is available. I do have him on mute for the time being because I needed to make a record, and there is a very lengthy history with Mr. Brooks during this case of him talking over me and my inability to make an adequate record if I am in a constant back and forth with him and trying to talk over him. And so I, yes, made the decision to utilize the mute function on the incoming audio. I know he disagrees with my ability to do that, but I believe it is consistent with ensuring dignity, order, and decorum that when appropriate, he be muted. I will advise Mr. Brooks once again that although he has lost his right to be present in this courtroom, he can reclaim the right to be present as soon as he is willing to conduct himself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. That includes not interrupting the court. That includes respecting when the court renders a decision by way of an oral ruling, even if he disagrees with it. So with that, I will advise him that once the jury is brought out, I will unmute him. I expect that he will be respectful of them, and I expect that he will not interrupt as the court goes through the couple of final jury instructions I need to go through, including the reading of jury instruction 160, closing arguments of the parties. And then I will turn it over to the state, but I will unmute him at that point. So should he have an objection, he will be able to state objection. I will be able to rule on it. And again, I expect him to honor whatever the ruling that is made. And if he does not do that, then I will utilize the mute function. If he doesn't have it, we'll make sure he has the objection sign. And if I see that, I will unmute him to hear what it is and then make a ruling accordingly. Attorney Hopper.
Your Honor, two quick things. Please, could you confirm that the audio and video are working in the next courtroom?
Your Honor.
Shaking your head, they've done that. Thank you.
Your Honor, I'd like some cheese.
I don't know if you want to do it now or at a later time, but I think we should make a record, as I will be displaying a PowerPoint during my closing argument, throughout my closing argument, and I'm not sure how that is projected in the next room or how it affects what we see in this room, Your Honor, but we should make a record of that at some
Don't you
point.
know?
Thank you. My understanding is Madam Clerk has the ability, so that is displayed not only here, but in the neighboring courtroom. If you would be so kind as when you start displaying it, just make some type of record, excuse me, so that the bailiff who's over there, if it's not being properly viewable, if it's not viewable, that we can stop and adjust
Sure.
accordingly.
Okay. Thank you.
If you would like, before the jury comes out, we could do a test,
Yes, could we please?
please.
I don't know if I want to read locals chat now, Darcy. That's scary. Oh, that's not bad. That's good.
Madam Clerk, would you confirm with the clerk over there that the PowerPoint is also viewable?
They can see it.
They're taxing that
All right,
one,
and
Nick.
it should be similarly to what we see. So the monitors will display the camera that Mr. Brooks is appearing, that is on Mr. Brooks on the left-hand side of the TV, and then the 4 cameras for this courtroom are on the right-hand side, but it's probably maybe a quarter to a third of the screen, and then the remainder of the screen is the PowerPoint. The monitors in the courtroom that Mr. Brooks is in are no different than what they are here. He would have one at the table, but there would also be the very, very large TV monitor above the clerk over there. Well, it's smaller, and then the very large one over the witness stand. So it would be very similar to what is here if he were present in this courtroom. And again, I know that the diagram, it's probably not the most easily seen from a camera, but it's really no different than what I'm looking at the moment. So I appreciate you asking that I make a record of that. I would further make a record that there are headphones on the table where Mr. Brooks is currently standing. He has not put them on, but they are available should he want them. All right, then are you turning off all right, PowerPoint? Let us know when you need that function, and then Madam Clerk will be able to make that viewable in both courtrooms.
Very good, thank you.
All right, with that, the jury is to be brought out.
Okay.
Here we go. Here we go. Yahoo!
All rise for the jury, please.
you gotta talk like that to me? Bibbidi bobbidi boopity. Spicy pizza. Pretty Mama Bear saying no box for today. Yeah, I think it's but he does not have them with him because he's.
Thank you, everyone. Please be seated.
You don't need all that with you today.
Ladies and gentlemen of the jury, when I read the jury instruction to you previously regarding credibility,
Oh no,
I had
Dale's waving them
a
off.
prior version of the jury instruction. Now, what I read to you
He's just saying hi
in
a
the
lot. I
very
don't know.
beginning, at the very beginning of this case, was the most recent. I am going to read a short paragraph, but
dying.
also tell you that in the packet that will be sent with the jurors to the jury deliberation room, it will have the complete instruction, and it's instruction number 300, excuse me. And this is what I want you to know about credibility. In your determination of credibility, you must avoid any and all bias based on the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. Consider carefully the closing arguments of the parties, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given you by the court. With that, I will ask Attorney Opper to start with her closing argument.
Here we go.
Go ahead.
And Madam Clerk, if you would please turn on the PowerPoint.
Yes. Oh, hold on one second. Mr. Brooks, do you have an objection?
I
Nothing.
thought I was supposed to be unmuted.
You are now. All right. Attorney Opper, you may start.
You went
Thank
through
you,
all that
Judge.
just to be unmuted?
Good afternoon, everybody. It's kind of nice to stand here in the middle of the courtroom, you know, all week or the last 3 weeks. They shoved me at the end of the table because I'm the lefty in the group. It's nice to be able to look at you all and say thank you. Truly thank you. Each and every one of you. I want to express our sincere gratitude from the prosecution team, myself, Deputy District Attorney Leslie Basie, Assistant District Attorney Zach Woodshow. There's no one in this courtroom that does not realize the sacrifice that you've made serving your community in this very important task. You've put your lives on hold. I don't even want to hear from your bosses. Thank you. You've watched these proceedings and you've noticed as we sit at our prosecution table, we don't have a client at our table.
Oh, she's
But
getting
rest
it right
assured,
away.
we do represent someone. We represent the people of the state of Wisconsin.
We'll
It's
see.
an entity. I can't bring it to the courtroom. People enact laws. People want to feel safe.
It's gonna be
People
Schoolhouse Rock.
have representatives in Madison or Washington, D.C. that set standards, rules that we all are expected to live by. And when those rules are violated, prosecutors step in and enforce the law. Darrell Brooks does not represent anybody. He does not have a client. Darrell Brooks is the client. Darrell Brooks is the defendant. The state of Wisconsin is the plaintiff. It's really that simple. And it's consistent with any other criminal case you've ever heard about at any other time in any other jurisdiction. It runs the same, no matter what state or federal.
Yes. This is a very smart way to handle this.
I'm going to ask you for your guilty vote at the end of my comments. It's up to you. I can't tell you to do anything, except I'm going to say one thing to you that I wholeheartedly ask you to obey.
Attorney Opper, I'm sorry for the interruption. Your objection, sir?
Mischaracterization of who I am and the way it was said. I feel like it was talking down.
All right, your objection's noted. It's overruled. The state may continue.
You must not consider anything about Darrell Brooks other than his conduct in downtown Waukesha on the evening of November 21, 2021. Nothing he's done before that, nothing he's done since that. When you go back to that deliberation room, please obey Judge Darrell. Confine your comments to his conduct on November 21 of 21. Is he guilty of the 76 counts that he's been charged with? That and solely that should be your topic of discussion. So, what are the charges against Darrell Brooks? Thank you for your patience in listening to the jury instructions. They must be read for each and every count. But sadly, they can be summarized very quickly like this as far as the actual counts. Counts 1 through 6 are first-degree intentional homicide while armed with a dangerous weapon. Counts 7 through 67, first-degree recklessly endangering safety while armed with a dangerous weapon.
That's a lot of counts.
Counts 68 through 74, hit and run causing death. Counts 75 and 76, bail jumping, and count 77, battery.
Whoa.
Mr. Brooks, what is your objection?
You can't just say.
I have 76 charges, not 77.
Pretty sure you got 77, bro, dog.
It's a mischaracterization of the charges.
That is correct. It is sustained. It should be count 68 through 73, I believe, and then 74 through 75, and then 76.
Thank you, Your Honor. I do apologize for my math skills.
Oh, well, you won that one,
68 through
Darrell.
73, 74
Good
and
job.
75 are bail jumping, and 76 is battery.
Look at these
I
prosecutors
apologize
just
for that
lying
mistake.
on Darrell. These lying prosecutors.
We're going to talk about counts 1 through 67 in detail. Counts 68 through 73, hit and run causing death, in my opinion, are easily summarized as this. He never stopped. Never.
Just like Chili DeCastro, he never stops.
Bail jumping, he was out on bail for 2 files in Milwaukee County, facing felony charges there. He was ordered to not commit any further crimes. If you believe he was involved in any of the conduct charging counts 1 through 67, you should find him guilty of bail jumping. Battery, that relates to the split lip and black eye suffered by Erica Peterson. We told the story kind of backwards. We started with the battery for background. First-degree intentional homicide. You've seen this in our opening statement. You've heard it from Judge Darrell. Did Darrell Brooks cause the death of the victim, a victim? Did he act with intent to kill, meaning either the mental purpose to take the life of another or was aware that his conduct was practically certain to cause the death of another human being? Count 1, Ginny Sorensen. Count 2, Lee Owen. Count 3, Tamara Durand.
Well, I got some.
Count 4, Jane Kulik. Count 5, Bill Hospital. Count 6, Jackson Sparks. Those are the individuals who lost their lives because of the conduct of Darrell Brooks.
Showing those pictures of them is going to be very powerful right now.
From there, we go to reckless endangering safety. What is that? In this case, it means that through his reckless driving, he endangered the safety of other people. And he did so demonstrating utter disregard for human life. Now, behind me is State's Exhibit 15. It's also on the PowerPoint. If you choose, you may have this chart with you in the deliberation room to help you walk through each of these counts if you find it helpful. It's up to you. If you don't want it, you don't have to have it. But it will be available for you if you ask for it. And it'll take you, as we did in our presentation of the case, right down Main Street and address all the counts that were involved, all the counts that were charged. To prove reckless endangering safety, and I'm just going to go back one slide, nowhere do you see there that we have to prove any degree of injury to anyone. Never once did Judge Darrell instruct you that somebody has to be physically injured. Now, Detective Casey told you that was the standard we used in deciding of all these hundreds of thousands of people who is included in these charges. And a decision was made by the prosecution team to include people who were physically injured to be efficient in our prosecution. And so everybody up and down the street, I would argue, had their safety endangered that day. I didn't charge 5,000 counts. We selected
Could have.
61 counts of people that we can identify by name in Exhibit 15 that were injured by the conduct of Mr. Brooks. Those are the people in green. People in red are the fatalities. And we presented this case to you in much the same fashion that is presented here on Exhibit 15 as to how the injuries occurred going down that street. So we are absolutely held to our burden of proof and the elements for each offense that Judge Darrell instructed you on, but we are not required to prove any injury to anybody.
Pull up right now, guys.
The question is, was their safety endangered by his reckless conduct, his reckless driving? Now, some of the groups, it's pretty easy. They walked in a formation, and you can get a photograph or a diagram, and you can kind of see pretty easily who was located where, right? And you can think back to the videos that you've seen for each of these groups and remember, and you'll see them again, the path of the vehicle as it went through each of these groups. This is South Band, of course. All of these names that are being displayed on the PowerPoint Exhibit 21 are on Exhibit 15 in green for Waukesha South Band. Pretty much the whole left half of the formation was endangered by the safety of Darrell Brooks driving up the side of that band. The extreme dance team. It's a little difficult to read, but again, this chart was marked as an exhibit. It's exhibit number 33. If you want it, you can have it in the jury room. The names on this chart will match the names for the extreme dance team on State's Exhibit 15. All of the girls that were struck and injured as they marched with the extreme dance team, plus some people on the back that were handing out candy or serving in support roles as the unit made its way down the street. The dancing grannies. State's Exhibit 54, the formation that they marched in, who was located where, and your recollection of how that SUV zigzagged through that group. And you can just see the names and match it up to who was injured and killed versus who wasn't. Now, one of the big things in this case has always been, why did this happen? What was he thinking? Why did he do this? Again, those are things I don't necessarily have to prove to you. His intent, I do have to prove, and I submit without any doubt. There's overwhelming evidence that this was an intentional act by Darrell Brooks and an act of utter disregard for human life. I say that for these reasons, folks. Number one, first and foremost, just stop driving. That's it. It's really that simple. Not one person had to be hurt that day if he would have just stopped driving.
Excuse me, Attorney Opper, your objection, sir?
You specifically, I'm sorry, can I be heard?
Your objection, sir?
I didn't know if I was on mute or not.
You're not?
You specifically said
I
in
objected
your
just
jury
to check.
instructions that intent cannot be, you can't look into someone's mind, I think is what it says, to find intent. So how could that be characterized as someone knowing for sure intent or not knowing for sure intent?
You're making an argument. You'll have an opportunity to do that later. Your objection's noted. It's overruled. The state may continue.
I apologize.
We showed you at the very beginning, remember our first witness was Sergeant Warner, the man who was the incident commander for the parade. We put up another map. I think it states Exhibit 1. You can have that if you want it. Shows all the positions of all the police officers and the reserve officers, the barricades, the squad cars. How do I know it was intentional? Because even Darrell Brooks told Detective Carpenter, I could tell something was going on downtown. No reasonable person would drive upon this area, see the squads with their red and blues on, see the officers in the street with their bright yellow vests, see all the people milling around, see the floats lining up and the participants getting ready, and not know to drive safely, slowly, and obey officers. The barricades help us prove it was intentional. The police presence help us prove it's intentional. The parade participants help us prove it's intentional. And the parade spectators help us prove it's intentional.
Excuse me, Attorney Opper, your objection, sir?
Speculation as to what the alleged defendant said he saw. It
Sir,
was never.
Your objection's noted. It's overruled. This is closing arguments, not the evidentiary phase. Go ahead,
So
Attorney Opper.
how can speculation be made to what was saw? if
Your
that was never
objection's
testified
noted. It's overruled. Continue, Attorney Opper.
Honking the horn. Quite interesting that Mr. Brooks asked so many witnesses if they heard the horn honking. Some of them said they did at the beginning of the parade. Yeah, I heard a horn honk. Most of them said they didn't. The horn honking cuts both ways, folks. If he's honking his horn, that means he can see something's in front of him. That means he knows there's an object in the road. You can rely on your common experience in your affairs of everyday life. If you see something in the road and you want to alert the other person to your presence, you will honk. But you do not have the green light to then just keep going if they don't move.
Oh, I thought that was.
He knew they were there.
Johnson.
Intent.
She's doing a great job.
I've skipped one. I'm sorry. Going back to my street, number 15, I failed to include the Catholic community. That's just one of the photographs showing the people that will match up to Exhibit 15 from the Catholic community of Waukesha.
She's
There's a
doing
lot
very
of
good job.
photographs identifying the people that were marching with that group. The parade started. This is the starting point, or at least near the beginning, right? This is the area We showed some videos of the groups passing by in this area. We heard testimony from 4 different police officers standing in 4 different spots near here, telling of their 4 different efforts to stop him. Intentional. Sergeant Wanner's back here testified that this red SUV blew by me. I waved both arms over my head. I'm in a police uniform. I have an unmarked squad, but I have my red and blues on. And he blew past me. He gets down here to the corner where Detective Casey is standing. Detective Casey runs out into the street, gets close enough to put his hand on the hood of the car. He keeps going. He comes down, turns onto Main Street, gets in this area of East Avenue to the south and Buckley Street to the north. This is where he encounters Officer Schneider and Officer Buttrin. They each make a separate effort to stop him, and he keeps going. 4 police officers. It's intentional. He had plenty of opportunity to just stop anywhere along the way. One of the officers testified to it. I think it was Officer Schneider. If this was an accident and he mistakenly wandered onto the parade route after passing all this, and he mistakenly wandered onto the parade route at any point, all he had to do was stop. They could have paused the parade. They could have moved the barricades and escorted him out. He didn't. It was intentional. He went on for 4 blocks. 4 blocks. It was intentional. He reached speeds of approximately 30 miles an hour. That's intentional. He plowed through 68 different people. 68. How can you hit 1 and keep going? How can you hit 2 and keep going? How can you hit 3 and keep going? Didn't faze him a bit. He kept going until he got to the end, and there was no more bodies to hit. It's
Your objection,
intentional.
sir?
Mischaracterization
I'm
of the evidence.
No, it's not. How did
Noted, overruled.
His conduct when he left the parade route, we'll get into this. His flight, his hiding, his panic, his desperation to run. Get the hell out of town as fast as he could before the cops came. That shows his intent. His interview with Detective Carpenter, we spent several hours playing you snippets of that interview. How telling was that? Never once did he say any of these things. Never once did he say, like he told you in his opening statement, it wasn't an accident. It wasn't intentional. Never said that to Detective Carpenter. No, he came up with some convoluted story about, I got a ride out here from a buddy in a tan Kia, and then I left to go meet Erica, and we got into a fight, and then I went back, and the other guy got into a fight, and he was leaving, so I took off on foot. Absolutely nonsensical story. Does not match up with the known evidence in this case.
Overruled.
He never
I didn't
stopped.
even state the objection.
This is closing argument. She may continue.
I'm going to play this slide, which is a snippet from State's Exhibit number 53.
You are allowed to object at closing.
Go ahead and play with sound, please. That was just a snippet that I selected because I thought it really captured the environment that so many witnesses tried to explain to you, right? It's a Christmas parade. People are there with their families, their little kids, their grandkids, their neighbors, their friends, strangers, standing next to strangers. That's what's going on Main Street. While that's going on Main Street, this is going on. Remember this? This is the gas station on the corner of Barstow and North Street. While the units are marching down Main Street, entertaining the crowd, Darrell Brooks is driving recklessly. He's enraged, and he's arguing with Erica Patterson. Why is this important? This is important because before he even gets to the parade route, this is how he's driving. He drives the wrong way down North Street and then acts like it's everybody else's fault in the world.
Your objection is noted. It's overruled. You may continue, Attorney Opper.
When he finally pulls into the gas station, he rolls down his window and yells at the driver who's properly stopped at the stoplight that it's somehow that guy's fault that Darrell Brooks is trying to drive the wrong way down North Street. And from there, the rage continues. We get to this point, State's Exhibit number 3. Please play. The video is playing. You can see the pushing match between Darrell Brooks,
He's being peaceful.
Corey
mostly.
Runkle, Erica Patterson, and Nick Kirby.
Mostly peaceful.
Watch this. He turns to get in the car, flips up his hood, and goes and gets in the passenger seat. I'm
Sir,
sorry,
your
driver's seat.
objection?
How long are we gonna mischaracterize testimony?
Sir's argument, I've heard nothing improper. Your objection's noted. It's overruled. You may
We get it.
continue,
You're
Attorney
not
Opper.
Darrell Brooks.
They need to know they can nullify.
That's it. He drives off onto the parade route. From this moment,
Wow, she just blew past that. Good job, Sue.
right here on
Don't
Exhibit
even fucking
15,
dignify it.
you're watching it.
Wow.
He's enraged. He's angry. Flips up that hood, and he zooms past Sergeant Warner, past Officer Casey, onto the parade route. Now, there's no doubt for the first 2 blocks, he does not strike anyone. And as we've discussed, some even said he was driving at a reasonable speed
Not for lack of effort.
initially. By the time he gets past Officer Buttrin and Officer Schneider in this area here of East Avenue, past East Avenue, and clearly once he gets past Barstow, that's where it starts, right? That's where it starts. Nicole White, our first victim, walking with Remax and hot air balloon. Knocks her over, keeps going, runs up and over the backs of Waukesha South Band, hits the green children spectating on the sidewalk, keeps going, runs over Kelly Grabo and her daughter Adelia, walking with Burris Logistics, keeps going, plows through the entire extreme dance team just before the 5 points, keeps going, hits Deborah Ramirez and her son Isaac spectating on the south side of the street, keeps going,
Yes, Kathy, it's closing
clears
arguments.
the 5 points area, hits Jane Kulik square on, causing her to go up on the hood of the car, and then fall off and drives over her body. He doesn't stop. He keeps going. runs through the kids over by the steaming cup. We heard the parents testify about little Brinley and Kelsey and Owen that were standing there outside the steaming cup. They were struck by the red SUV driven by Darrell Brooks. Keeps going. Plows through the grannies in that zigzag fashion, striking most of them, injuring them, killing them, keeps going, gets down here to the end, and goes through the Catholic community. The witness, remember Holly Berg, she testified about that mobile gas station incident. She said she was standing down here in this area. She said, I saw 15 to 20 people fly in the air. They look like bowling pins. And when you saw the video, she's absolutely right. It's a terrible description when you think these are human beings, but that's exactly what it looked like. When does the intent exist? Doesn't have to be even for a second. I'm not telling you who set out that morning to cause this carnage. But when he became enraged back here, he didn't give a damn who or what was in his way. He intentionally went on. I'll show you. Motive. I don't know why he did this. Folks, I don't know why. Other than the rage. He's right. You cannot read minds. Neither can I. But the law doesn't require you to. The law gives you a way to reach a conclusion as to what is somebody thinking. And it's right here. Decide it based on his acts, words, and statements, and from all of the facts and circumstances. I've already been through many of them. I want to show you what I mean. Look at this. Was there room for him to get out? This is way back at the beginning. This is Officer Buttrin's squad video. Way back at the beginning. That's Buckley Street here that you're looking at. Look at those barricades. Look at the sparse crowd. And there's Officer Schneider in her yellow fluorescent vest on the left side of the picture, about to run into the street and stop him. Intent. I'm going to play this video for you because, folks, for me, this is where it becomes crystal clear. You watch this video, the first thing you're going to see, if you direct your attention to the left side of the screen, you're going to see him hit Nicole White. Knock her to the ground and keep going. Now, if that was the end of the story, you may sit here and say, Madam DA, I don't know how you conclude intent from that. Maybe it was an accident. Maybe he didn't mean to do it. But watch what happens in this video after he knocks Nicole White down and tell me this does not prove intent. Please play.
Yeah, here we go. This seals the deal on intent, guys. Can you blame her? She's had to deal with this bullshit for how long now? That he won't accept responsibility? She's pissed.
Keep watching the left side of your screen.
Yeah, notice he ain't saying a damn word right now. He's being a little bitch. Darrell bitch made Brooke.
Oh my fucking God.
That's intent, folks. No reasonable person is going to come across a group of teenagers playing band instruments, drive over them, and keep going. That's a still shot of the same thing.
Can you send it to me on Twitter?
That's intent.
I'm sorry to interrupt your objection, sir.
How can you tell the jury what they supposed to think?
It's proper argument, your objection's noted, it's overruled.
That's the part of the
I would
argument. It's
argue that
persuasion.
I would say that it's improper.
It's
and
persuasion, Darrell.
I move
Mr.
for a
Brooks, I made
mistrial.
my ruling, I'm going to mute you if you don't follow the rules.
I
Exhibit
move for a
one,
mistrial.
It's
exhibit
persuasion.
152. Clearly intentional conduct.
52.
Clearly intentional conduct. State's Exhibit 93. We asked the court to take time to have you go look at this car in person because it's remarkably amazing that this damage was caused by human beings.
Looks like
That's
you hit a
intent.
deer. Even a deer doesn't cause that much damage.
This is an excerpt from State's Exhibit 154. Maybe a little hard to see. A lot of that laying in the front part of this photo
Oof.
are shoes. Remember what Dr. Vidritsky said about the shoes and the feet, the scuff marks on the toes and the ankles? Look at all the shoes laying in the street. This is the area at the end when he ran through the Catholic community. All the shoes laying there because of the velocity. Remember, the medical examiner talked about the velocity. It's not just the speed, it's the velocity. The power that these people were knocked right out of their shoes. That's intent. The flight, the hiding, changing his appearance. He had to go through some effort, right? Crawled up in this playhouse, ditched his sweatshirt and his sandal. The other sandal seems pretty reasonable. He dropped it when he was jumping over a fence. Changed his appearance. Please play.
Excuse me.
Intent. What's he running from? What's he running from if he's just a lost guy with no ride back to Milwaukee? What's he running from as there's cops, sirens wailing in the background? Whoops, that was me. So, State's Exhibit number 130. Put that up here quickly. Take this one. Thank you. I'm not going to go through this whole thing, folks. Suffice it to say, after Officer Skolton tried to stop the threat at that intersection at the top, Wisconsin Avenue, and he blew through the barricades there and drove south on West Avenue over to Prospect Court, cutting through the yards and ditching the vehicle on Maple. Heard all the testimony about the commotion on Maple. The eyewitness testimony from Officer Sailors, off-duty police officer who saw this, saw the defendant, Darrell Brooks. He identified him for you in this court. Get out and run from this car. And how we tracked him through the neighborhood. And again, the desperation, whether he had to ask or use veiled threats like, I won't hurt you, but I need your phone. He was absolutely desperate to get out of there until he took refuge in the home of Daniel Ryder. Now, remember the interesting thing, folks, none of these witnesses in this area knew anything about what happened at the parade. None of them were there. None of them were there. So some of them tried to help, some of them didn't. Daniel Ryder did, and it's actually probably a really good thing that he took him in because it stalled, right? It stalled him from keep running, kept him in one place until the cops could close in and get there. Now, Mr. Brooks repeatedly asked witnesses who had just watched their loved ones get struck by this SUV if they happen to catch a license plate. State's Exhibit 150, there's the front license plate. Definitely a little blurry, but definitely you can make it out. State's Exhibit 151, there's the rear plate. State's Exhibit 175, there's Darrell Brooks in his music video with the same car and the same license plate. There's the key to the Ford that was found in Darrell Brooks' pocket. There's no doubt Darrell Brooks is the person responsible for this. Because this man in this picture is the same as this man in this picture wearing this sweatshirt. And again, it's a little hard to see, but you can ask for these exhibits in the jury room if you want. The photograph, you can see this design on the front of the sweatshirt if you look close enough. This is a sweatshirt from the playset that has Darrell Brooks' DNA on it, according to the crime lab. That's him right there. That's Darrell Brooks driving off into the parade. That's Darrell Brooks driving in the parade. That's Darrell Brooks driving in the parade. That is also Darrell Brooks driving in the parade. And so is that. And he kept asking people about the tints on the window. Well, guess what, folks? You don't need to see the tints on the window when the windows are rolled down. And there's clearly one person in that vehicle in every one of these photos. And it's that man. And it's that man. And it's that man. Darrell Edward Brooks Jr., date of birth 2/21/1982, on his identification card issued by the state of Wisconsin.
That could be anybody's driver's license.
In all capital letters, Darrell Edward Brooks Jr. This was in his pocket.
Ooh, she getting a dig
when
in
they
there.
arrested him.
Good job, Sue.
So this
Sovereign citizen.
entire shenanigans that he's presented to you through his questioning of witnesses about I'm not Darrell Brooks and that's my name and I don't know who that is and I don't consent to being called that name. It's just nothing but a distraction. It's Darrell Brooks. It's the man who drove through the Waukesha Christmas parade and killed people, injured people, endangered the safety of people.
I'm sorry. Your objection, sir?
Your Honor, with all due respect, I would appreciate the quote unquote language what does she mean by shenanigans and this and that and the third?
Sir, your objection's noted. It's overruled. The state may continue.
That's allowed to be used.
Well, can she tone that back? Because if that was me, if I would have said
Mr.
something
Brooks,
like
your
that, it would've been a
objection
problem.
is noted. It's overruled. These are closing arguments.
He's doing a very good
There's
job.
nothing
guys.
improper. It's noted. It's
wanted to-
overruled. She may
I
continue.
just wanted to be fair.
You'll have
Your
an
Honor, that's it.
opportunity to respond, sir. Please let her finish.
So I can rebuttal.
Yes, you get to
Go
have
ahead,
your
Attorney
closing
Al.
argument.
Thank you.
Imagine that,
I'm going to
Darrell.
conclude my comments with this, folks. I'm going to show you the video, a stitched together video of all the carnage caused by Darrell Brooks, and I apologize.
Stitched together.
This is important that you know what he did. It's important that you think about the women like Nicole White
I've seen the supercut before. It's
and
brutal.
Kelly Grabo and her daughter and Jane Kulik, who were just there with friends and co-workers supporting a local business. The teenagers marching in the band, representing, wearing their school colors. It's important. The boys and girls with the Blazers baseball team and their coaches doing nothing more than handing out baseball cards. The young girls in the extreme dance team. Can you imagine how many hours they spent practicing that routine? He drove right through them without a care in the world. The grannies dancing their way down the street, perfect step. every one of them. Catholic community there, as Father Matt said, spreading the light of Christ in the weeks before Christmas. He snuffed it out. It's time for Darrell Brooks to stop running. It's time for him to stop lying. It's time for him to be held accountable for his actions. Darrell Brooks cowardly rammed his way through this parade, violently killing and injuring so many people. I'm going to stop talking and play this video, but please, I ask you to add up the evidence, use the map, 15.
If she ends
You
on
can
this,
check
this
off the
is
names. We've covered them all.
top tier.
Walk down that street like we did with you. Return guilty verdicts on all counts. Please. Please.
Screen back up.
No, I need one more. Yes, please.
Because most people at parade weren't carrying straps, Dad.
Go ahead.
This powerful way to end. Emilio, no, there is no death penalty in Wisconsin. He faces life without parole if he gets convicted. Okay, I wouldn't say she's a goat. This is a pretty easy case to prove. The TV stations have FCC guidelines to follow. They can't show it. Darrell, God can't save you now. It's too late. Okay, apparently it's on Pornhub if you want to see it. They're watching a supercut of him from the beginning when he missed that little kid to him plowing through the band, unedited and uncensored. They're watching him murder 6 people and wound 60 some odd others. Not a juror, that's somebody in the gallery. Family, probably.
Thank you. Before we continue with Mr. Brooks's closing arguments. I am going to take a short break. All rise for the jury, please.
Am I muted?
No.
But he just was unmuted technically.
Jury should know that they can nullify.
You are muted now.
I was to say, I don't know why you didn't mute him. Darrell, you're going to blow it, brother. You're going to get like 2 seconds in. Well, you could see it.
I think you will be in recess for about 10 minutes.
You could see it on Pornhub. But yeah, it's if you have not seen people die or you're not comfortable watching people die, it's a pretty brutal attack, even though you don't see blood and you don't necessarily see exactly who dies. It can be rough if you haven't seen death before. So, tell this thing, is there a chance for a mistrial? No. He's not going to be able to. She's not going to let him. And you don't generally get to orchestrate your own mistrial as a defendant. So don't get worried about that. Don't get worried about that. That was a very powerful and I think very succinct closing argument. They didn't go on too long. They hit their points. They told a story. They talked about all the groups. And then they focused on the 6 homicides. I thought they actually did a very good job. I didn't keep track of time, but whatever time they have left, they can save for a rebuttal argument. But no, that was a very powerful, very short, very sweet closing argument for such a big case. Yeah, and everybody was asking before, how are they proving intent? And I mentioned this before. Your actions establish intent. He didn't stop. And then he kept on driving over people. Well, at some point you've established that you don't give a shit and your intent is to hurt people. So that's how they establish the intent. Walter Malone says, can he plead guilty anytime or does he have to go through the motions? I mean, he could plead guilty right now if he wanted to, but for the prosecution, they're going to say you're pleading to the whole indictment. There's going to be no plea offers. He'd have to plead to the indictment as is with all the enhancements and all the specifications. So no, I mean, at this point, there's no change in what'll happen. If he enters a plea now, it's just like getting convicted. He's going to get convicted all over. Sky Queen said about 50 minutes. Peachy Keen says about 43 minutes. And think about this. For most of you, that probably didn't seem that long at all. I thought maybe about 35, 40 minutes total. But it's just like a good movie or a good story or a good narrative. Time flies. You don't realize how long you were involved. So that was a good sign that, just focusing in on it. That's a good storyteller is very important. And I've said this before and I'll say it again. A jury trial is sales at the end of the day. Now, this is an easy sell for Sue, but she still did it phenomenally well. So let's get through some of these starred comments and some super chats too. Melissa Ann Mead says, can they ball gag him? No, that would be highly prejudicial in front of the jury. If they did that, he probably would get a new trial immediately. Jessica Bodahane says, if he brings up that BS, can the prosecutor say anything about it? Yes. And Sue Opper did a great job. She nipped it in the bud. She head him off at the pass. All this is gibberish. Hey, look at his name. It's all in capital letters. She did a great job at crushing that. So I think that's done. He could try to make those arguments and they're going to fall apart. Jim is saying, can he possibly have an angle of appeal because the judge hasn't once held him in contempt? No, because the judge has the right to decide whether or not he gets held in contempt. That's judicial discretion. The argument of, well, I was such an asshole, but you didn't punish me, isn't going to work on an appeal. Because I'll say the judge was trying to work with you and was being very patient. Dr. Mimo says, how was my trial this morning? Did not have trials, had a couple of pre-trials, and I had a pre-trial this afternoon. They went okay. Nobody went to jail. That's always a good day. But nothing really interesting happened. And by the way, I forgot to mention, if you're new here, my name's Sean Martin. I run the channel Potentially Criminal. I am a criminal defense attorney out of Cleveland, Ohio. And yeah, this morning I didn't get to cover all the boring parts because I was in court. YouTube Sucks Now says chances for trying jury nullification. Well, 100% confirmed. Tristan She says, if there's a juror that's heavily ignorant and anti-censorship, angry against state mandates, could he walk? It's always a danger. There's a juror who's going to walk in there and say, sorry, don't care, you can't convince me. But it doesn't sound like that happened. They did a pretty strenuous voir dire, so I don't think that's going to happen. Should the prosecution allude to his poor impulse control from Cole Murdoch? They didn't really do that, but they pointed out his rage and that he just couldn't control. Like he just got mad, and nothing he did made any sense. Kathy HB for $4.99. Thank you for the super chat. Says, if he's a soft citizen, why is he whining about our Constitution? Once again, that is a mystery of the sovereign citizen movement. Why do they make these arguments, but then cling to the Constitution? Nobody really knows. It's all gibberish. Free Flyer 1978 for $10 says, thank you, by the way. If he had brains, he would have focused on witnesses who said he was honking and waving to get people to move and try to beat the intent portion. The only thing he had going positive in his favor. And that's true. And I assume his public defenders were going to try to do that because he still killed people and still ran them over. But negating the intent, yes, he might have had a chance of not having mandatory consecutive life sentences without parole, had they been able to show that. But that would have been a very, very hard burden to meet. So they still very likely would have failed. But yes, that was his only real successful avenue that he could have pursued. Pootie Tank says, has a sovereign citizen ever defended themselves and won a court case? Lol. No, never heard of it. But there's got to be some place somewhere one of them won. And if they did win, it was on a procedural issue or a factual issue, not because of their nonsense arguments. I doubt there's ever been a jury who goes, well, Your Honor, we done reckon that that gold fridge on that flag there, yeah, he's not guilty. I don't think that's ever happened. Now, I'd like to say never, but always and never, two very dangerous words. So I very, 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 very hard to believe that it's ever happened. Chris Kelly says, in your experience, if he's convicted, is there a high chance he'll get booked when he gets to prison? I mean, I don't know. Maybe. It all depends. I mean, he's been there before. Who he's pissed off, what his reputation is. Because, your reputation, if you've been to prison before, it could follow you around. So, maybe not. I'm not going to have a fun time, I bet. No pants, baby. Yes, when he objected to the counts of the indictment. Yes, that is a proper objection. Objection, you're claiming I committed more crimes than I'm being charged with. He has every right to object to that. And you guys were asking, is objecting during a closing argument? You should really refrain from doing it, but sometimes you have to. And if the state's not properly telling the jury what your charges are, you have the right to object. So that's not a problem at all. Yes, and No Pants Baby says he ain't called Math Boy for nothing. Very true. Tales from My Shed says, watching from the UK. Well, thank you. I know it's getting kind of late out there. How could someone so inept and inadequate be allowed to represent himself? Because he has the right to defend himself. He has the right to self-representation, and he is competent from a criminal court standard. He understands, he can read and write the English language. He has a 12th grade education of a diploma or a GED equivalent. he has the ability, and he has done some effective cross-examination and practice in this case. So that's why he has the right under the Sixth Amendment to represent himself. AD for $5. Thank you very much for the super chat. Says, according to critical race theory, Darrell's innocent because he is guilty of being black and white power structure. No lies detected. Ryan Nolan for $5 says, thanks for being the only law tuber that stays laser focused on the trial for the entire proceedings. Thanks for taking the boring stuff seriously. I mean, this is the fun stuff for me. I don't mean to talk lightly about trials, but trials are fun. They're a lot of work and preparation, but when you're in a trial, I enjoy them. Yeah, I have trials starting on the 31st. Well, knock on wood. Apparently, we might have a witness who's sick. But trials are fun, and I look forward to this trial. It's a very tribal case. We got a lot of facts in our favor. I got a guy who's facing a couple felony counts, and we're going to go at it. I mean, it's going to be great. It's going to be amazing, and it's all about that focus and that intensity. I enjoy this stuff, and I think that's. I mean, I do it, so I enjoy it. I do this because I enjoy it. I enjoy in real life too. Let's see here. M. Rushid says, what happens if there's a sovereign citizen appellate judge? Oh, you would never get that far. I don't think there's ever been a sovereign citizen trial court judge anywhere. Nobody would ever vote for you. Think about this. If you had a guy running for judicial office, and they just had insanity like that, they wouldn't even want to run for it, because why would they run for something they don't recognize as a fictional corporate entity that oppresses and is part of a tyrannical government? Sovereign citizens won't do that, because it's like a Jewish guy joining the SS. Like, do you think about, like, hey, bro, is that a good idea? All right, I think I caught up on everything. So I think we'll see what's going to go on here. I'm going to catch up and see what you guys... Wow, you guys like explode when I try to read the rest of these. Also, by the way, your Brooks Coffee Company out of Waukesha, Wisconsin, you can get that mug at the link down below for Teespring if you'd like one, because it's the Brooks Coffee Company out of Waukesha, Wisconsin, serving relevant grounds since 2022. Kathy Hansen saying, I learned a lot through this trial. I looked up Illinois v. Allen. Actually, it's Illinois. You get a French. And I didn't know what a sovereign citizen was, so I looked it up. Looking up the sovereign citizen world is a deep, deep rabbit hole. Naked Lunch says she cannot let him back in there. She's got to try. She's going to have to try. I would argue she has to try to let him back in. To make him do his closing argument from a screen without giving him the chance to come back in, she's got to let him try. She's got to let him fuck it up. Also, just remember again, guys, I mentioned this real quick. You cannot, there's no death penalty in Wisconsin, so that's not an issue. Life without parole is what he faces on each count of murder, and those will be consecutive. So he faces 6, back to back to back to back to back to back to back, life without parole sentences. So he'll never get out anyway if he gets convicted. Melissa Ann says, yes, right now he's in protective custody, but that may change once he gets to the prison system. Dwayne Mansell says, are you aware of that dumbass delete laws on YouTube? Yes, I am. Chili Kate always wins. No, Chaucerian Fraud says it can be found on Pornhub as a morbid joke. No, that happens. You can put all kinds of stuff on Pornhub. There are gun channels on YouTube that had, for a while, as a joke to show YouTube's censorship policies, were putting their videos on Pornhub instead. In Range TV in particular was the channel. But no, you can find this video on Pornhub. I forget the link, and I don't know if putting a Pornhub link will probably get this stream nuked and me a strike, so I'm not going to do that. As much as I like being an edgy boy, I do like streaming, and I kind of want to keep this going. I put a little bit of work into it at this point. D. Coddle says appeals court reverses sovereign citizen's conviction for impersonating an officer on January 10th of this year. Sure, and there probably were constitutional and legal grounds and procedural grounds to overturn that conviction, but the appeals court didn't say, yeah, we buy the whole, yep, not all capital letters, and yeah, that flag had fringe on it. So it would have been a factual and legal argument, not the nonsense arguments. Let's see. Jed in Georgia. Yeah, this trial's not fun. No, I agree. I'm just saying in general, trials, I enjoy going to trial. That doesn't mean I push clients into them or ever want them to happen, but they are, it's some of the most fun you can have with your pants on, besides like driving a Ferrari or shooting a machine gun. Corey Hartley says, what is that video that's being showed? It is a supercut of him running around through the parade, like running everybody over. That's why you heard everybody just there are some video clips of this that are pretty nasty. There's that one shot. There's a shot from like somebody filming from on top of a balcony, like probably 3-4 stories up. And you can see the car just go boom, 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 boom through the band. And then he keeps on driving off. Yeah, it's Ellen Yates says, how do you defend someone that you know is guilty? Because everybody's entitled to defense. It's the state's job to meet the burden that they committed a crime beyond a reasonable doubt. If they can't meet that, it doesn't matter what the guy did or what I know. It's entirely their job. And my job is to represent whether I get hired or I'm appointed by the court. It doesn't matter. That person gets the same effort. Whether I think they're 100% innocent or I know beyond a goddamn doubt they're guilty, they get the same effort as well. Why? Because that person is up against the state. That person is up against the full force and fury of the government. And that individual should always be protected against the government. And if the government can't stick the landing, that's not my fault. It's just like a field goal kick. If you can't kick the field goal, you don't get to blame the defense. The defense, if you kick the ball, kick it right, kick it good. It's not my fault if it doesn't go through. My job's to stop you. So I just that's how. And I guess I'll say it like this. I view the Constitution with religious zealotry, okay? Yes, the first, second, third amendments, and then the fourth, fifth, and sixth amendments, though, I view with religious fervor. They are critical. We're the only place in the world with the protections we have. There is no place on earth I'd rather stand trial. No place on earth. I would never want to stand trial in any other country under any other country's laws, in a criminal context or a civil context. That's how good it is. Is it the best? No. Have our rights been eroded by a lot? Sure. But it's still better than anywhere else to go. And also, for those people who are truly guilty, that's who the rights are meant for the most. Because if we don't defend ourselves and protect those who are truly guilty, when it becomes your turn in the barrel, nobody's going to be there for you. And you won't have any rights. So that's why there is a reason. Defending that guilty man helps society, believe it or not. And Ellen, I hope that didn't come across as me being like angry with you at all. I get a little fired up about it. The police state just red coats. Yeah, depending where you live. Yeah, that's very true. YouTube Sucks now says a lot of judges run uncontested. Yes, they do. Yes, every person deserves an adequate and zealous defense, even the guilty. 100% Chessarian fraud. Matthew says it pays the bills. Look, I'm not going to lie. That's part of it too. I mean, hey, how many innocent people are really getting jammed up on like criminal charges? I mean, if your sole job is defending innocent people, you go out of business. AC says George Soros was a Jewish guy. He didn't join the SS. He collaborated
in the main courtroom prior
that
to reopening following the break. I did invite him back into the courtroom, and he is here. I trust you are ready with your closing argument, sir.
I'm ready to address subject matter jurisdiction as well, too.
The request is denied.
The last stand of the subject
Just
matter
for the record,
jurisdiction.
I was addressing it for both courtrooms here in courtroom number, I think it's 20.
Mr. Brooks, I'm going to bring the jury out. Are you prepared to present your closing argument?
You joined us in time, Adam. Here we go.
I would like for you to prove subject matter jurisdiction on the record, Your Honor.
I'm not addressing that any further than I've addressed already, sir. There's a written decision. I remind you of that.
In that written decision, did I receive, well, actually, I didn't receive anything. Was there copies made?
Mr. Brooks, I'm going to ask you one more time. Are you prepared with your closing argument? I'm going to have the jury brought out. There's no other legal arguments I need to address from you at this time.
I'm informed of what you're saying. I was merely asking, was there copies made of you said written decision?
Sir, my written decision has been filed into the record. That is done electronically. You were provided with a written copy previously. Are you asking for another copy of that, sir?
Yeah, because I don't have it.
As a courtesy, I'll have my clerk print off a copy and provide that to you.
Is it proven subject matter jurisdiction?
Your objection to the lack of jurisdiction has been noted repeatedly on the record.
Oh my God, I need more clause, guys.
It is a meritless argument. I've indicated that in my written decision as to why there is subject matter jurisdiction, and I will continue forward with
We'll talk about this, Jared.
the final stages of this trial, which I hope include your closing argument and then the final instructions to the jury.
I would hope it proves subject matter jurisdiction on the record too.
You've had this
All
paper
right, I will
15
instruct the
times,
jury
man.
to come out. For the record, the written decision is once again being provided to the
I accept
defendant.
for value and return for value this document as it is not based in lawful law. And it does not prove subject matter jurisdiction whatsoever.
Are you sure
Refers
about that?
to some complaint that was filed in the name of a trust, not my name.
Oh, the Sestaki Trust.
Were you aware of that, Your Honor?
Mr. Brooks, the jury has been asked to be brought out. I mean, I've requested that they be brought out. They're on their way.
Were you aware
Please
of
be
that?
prepared with your
Bring them out.
closing
Bring them out.
argument.
Were you aware of that, Your Honor? Or is that a tacit agreement that you don't have to answer any questions as a public servant?
Oh my God, you said it correctly. Tacit. You're
So that is a
learning.
tacit agreement.
Like through osmosis. You're learning now. My God, we do this trial for another 6 months. You actually might have a valid argument at
Record to
some
reflect,
point.
the jury is coming out.
Tacit. Oh, I salute you, Darrell. Oh, class reductionist. Yes, today he learned tacit. Hey, maybe by sentencing he'll learn some more words. Are those lawful clause? That's for you to decide.
Thank you, everyone. Please be seated.
Yes, it's the redemption arc. Let's go.
Go ahead, sir. You may begin your closing argument.
I'm not ready to begin closing arguments.
So this is your opportunity to provide your closing argument to the jury. Please start. I've started the timer of 1 hour.
I'm informed of that, Your Honor, but I'm not ready to proceed as I don't understand the reason why the questions asked before the jury was present were not answered.
He's
There are
going to
issues that
forfeit it.
needed to be addressed outside of the jury, as you always say, which I don't understand why the jury deserves.
Mr. Brooks, this is your opportunity to present your closing argument to the jury. Please do so.
I'm informed of that, but the jury needs to understand the truth, their rights, and their duties, as they have not been informed of their truth, their rights.
Oh no, he's
Mr.
going to
Brooks,
lose
the
it.
court has begun the instruction process. I read 73 pages this morning, and into the early afternoon, I have another 30 plus pages to read.
Did you inform
They will
the
be
jury?
informed of the law.
Did you inform them that they can
Mr.
nullify
Brooks?
the law?
Mr. Brooks,
Woo.
you do not have that right to request
Oh, he
that.
said it in front of the
And
jury.
Were
I'm
they
advising
informed?
you one more time, this is your opportunity to provide your
He's gonna say the
closing
gamer word,
argument.
the
Please
N-word.
begin.
I intend to when ready. I just want to know if the jury was informed that they can nullify the law.
He said it
Mr.
they
again.
are-
Brooks, you
that
have
they
no
have
right
the
to
power.
make that argument to the jury.
It's
Oh.
true. They have the power.
All right, I'm going to excuse the jury.
They should know that they have the power.
Please rise for the jury.
Wow. That's stone cold stupidity, but Jesus Christ, buddy. Yes, lady conspirian. Why would they want to nullify? Yeah, they are going to. We all saw this happening. I know, but not like this. And he just kept on
Thank you.
saying
Please
it,
be
so.
seated. Mr. Brooks, you do not have a right to request jury nullification directly from this jury. I direct your attention to the Bjerkas case, Bjerkass, that's State versus 163 Wisconsin 2nd 549. While you are not incorrect that the jury has the power to nullify, they don't have the right to do so, and no party has the right to instruct
Well, actually,
or to
they
request
do.
an
You
instruction or to argue jury nullification.
cannot-
You may talk in terms of fairness in general terms, but you may not go further. You may not argue that the jury should discard the instructions in the law and find you not guilty for that reason. You may not use the phrase jury nullification. You've done that now at least 3 times in earshot of the jury. Twice while you were in the other courtroom, I was able to mute half of what you said the second time, and then of course you raised that once again while in front of the jury just now. You also indicated you weren't ready to give your closing argument. Sir, the time has come for you to give your
Yes,
closing
Anthony,
argument.
this is live.
If you choose not to do so at this time, then you will forfeit your right to present a closing argument by your conduct.
I haven't made any such choice, so you can't
We'll talk about this.
coerce me into a constitutional right waiver when I have not waived the constitutional right. And I will not allow you as a public servant to do that. I have not made a choice.
Sir, the time has come for you to present your closing argument.
Are you making a judicial determination that you're denying me a constitutional right in
I have
open
not
court
made such a
on record
determination as of yet, but you can forfeit your constitutional rights
under
by
what lawful
conduct.
law?
Illinois versus Allen, State versus Anthony.
Illinois versus Allen does not reference anything pertaining to rights when talking about
In
closing
State versus
statements.
Anthony,
Illinois
the Supreme
versus
Court of
Allen.
Wisconsin referenced both that decision when it essentially extended the reasoning or adopted the reasoning of Illinois versus Allen to then find that a defendant could forfeit an important constitutional right by conduct. In State versus Anthony, it was not the right to be present in the courtroom, it was the right to testify.
Okay, so none
And
of those
the
that you just
reasoning-
named have anything to do with the closing arguments, Your Honor. You've used Illinois versus Allen repeatedly to when it comes to me being removed from the courtroom. Not one time did it bring up anything dealing with a closing statement or a closing argument. So how's that same statute being used for something that it doesn't even refer to or pertain to?
Mr. Brooks, the Allen decision, Illinois versus Allen, and the Anthony decision, which is State versus Anthony, are two examples of cases where a defendant lost a very important constitutional right because that right was forfeited by the conduct of that particular defendant.
And that was to be present in trial, correct?
The right to present a closing argument is no different. Because it is not evidence, it could be said that it doesn't even rank as high as the right to testify, which is guaranteed by the constitutions.
Which I was denied the
I'm
right
not
to
prepared to
be
make
able to
that ruling
testify to.
here yet today, but I will tell you this, sir. The time has now come for you to present a closing argument. There will be no further delays.
It's
I
not a
will not be
delay.
taking any further adjournments for you to prepare. You were advised yesterday that this court would proceed today with instructing the jury and with the parties making their closing
And you
arguments.
made that while
It is
violating
up-
my constitutional
Sir,
right.
please don't interrupt me because
Well,
you've now
you did.
interrupted me a couple of times.
No, once. So let's
Twice.
make that
Fired
correct.
up.
Once.
That's the third time.
Okay, now you can say two.
So, Mr. Brooks, I'm advising you yet again, the
I
time
don't
has now
consent to
come.
being called
That's
that name,
another
Your Honor.
interruption. The time has now come for you to present your closing argument to this jury. You were
And
brought back over to this courtroom for that purpose.
I'm going to let them
That's
know.
another interruption.
No, I'm going to let them know that they have rights and they should be told, informed of the truth. It's not me
Are
trying
you
to
telling
give.
me, sir, that
It's
you are
not trying
going
to
to
give-
let me ask you a
No, hello.
question.
I'm not trying to give any
Sir, you're
jury
interrupting
instruction.
me and you haven't let me finish. So are you telling me that you are going to disregard my very clear directive to you to not bring up the topic of jury nullification?
That's not what I said.
That's why I'm asking you.
I don't understand that question because that's not what I said.
Sir, you may not argue
Then
jury
what are you going to
nullification
do?
I'm
to
going
this
to
jury.
inform them of the truth.
So you're going to inform them that they have the power of jury nullification.
They do have you just said on the record that they have the power for,
Sir, I direct your
you
attention
just said that.
once
Did you
again.
not just say that, Your Honor?
Sir,
You
the
said I couldn't
jury-
instruct them.
The jury
on
has
that.
the power, but not the right to nullify.
Right.
A
You said the
party-
power. You said the
Listen
power.
to me,
That
sir.
is
You're
correct.
interrupting
He
me
is
once again.
100% correct.
So I'm going to inform them that they have the power.
Well,
Are you
can't do
telling
that.
me, sir,
I'm
that
not
you are
telling you no
going
such
to
thing. I just
disregard
told you what you just
my
said.
directive to you to not
Hmm.
raise the issue of jury nullification during your closing argument?
That's not what I said. You just read and said that they have the power to. That's what you just said, Your Honor.
Sir,
Yes.
State versus Bjerkus says and stands for the proposition that although the jury has the power of jury nullification,
They have the power.
no party has the right to argue for jury nullification.
I'm not arguing for it, Your Honor. I
In
just
that
want them to be
case,
informed.
The
I just want them
Sir,
merely to be
you
informed.
can
That's it.
call it informing, making them aware.
Yeah,
Whether-
they should be aware
You
of
are
the
not
right.
allowed to make them aware of their power to nullify.
How
That is
can I
an
not make them-
improper argument.
Your Honor, how can I not inform them that they have a power? How
Because
can I
that is
not
not a
inform them
right
of a
that
power
you
that they
have,
have? I'm not giving a new jury instruction. That's not what I'm arguing.
There is no jury instruction for jury nullification,
Yeah, I'm
sir,
not- I'm
because
not-
it's not allowed.
I'm not attempting to give them a new jury instruction. I'm merely attempting to inform them of the power that they have.
Mr.
That's not
Brooks,
against the law.
I'm advising you one more time. You may not raise the issue of jury nullification
I'm going
before
to
this
inform
jury.
them of the power that they have. I'm not
You are
giving them.
telling me
I'm
that
not
you
giving
are
them a jury
insisting
instruction.
on telling them about jury nullification. That's
That's-
what I hear you saying.
That's not what I said, though. Don't mischaracterize what I'm saying. You just read and said that they have the power. They have the power to do that. So how is
It's an
informing them?
inherent power that they have. They are not to be instructed on it. That
I'm-
is very clear in the law. In
Your Honor.
addition to, no, let me finish. In addition to the case that I just cited, I'd cite to you from the jury instructions, the law note on jury nullification 705. What that says, sirs, I'm not going to read it all. It's many, many pages. But the bottom line is, it is improper for a court to allow a defendant or a defense attorney to
MO so far
make an argument or make the jury aware that they have the power to nullify a verdict.
And Your Honor, you just added this last night. That's why I had to sit there for an hour in the holding cell and wait for you to change the whole paperwork, because I brought that up. So you never intended for this to even be an issue.
Mr.
It
Brooks,
never was brought up.
if you
But
think
then when I raised the issue,
if you
Your Honor, let
think
me
that
finish.
I'm not prepared to deal with an argument on jury
I
nullification,
didn't say, that's not what I said. That's
You are
not what I
missing the
said. In
mark.
all fairness, that's not what I said.
the record should accurately reflect that you were kept in that holding cell.
Why was I kept
so
in there?
that my clerk could finish
Adding a jury instruction that was not there.
76 verdict forms, and it's times 2
She
because
warned
there's a
you that she
guilty
was
and a
gonna have
not
this
guilty
Okay.
for each. No, let me finish.
So
or
how
you
did
interrupted me
I have? Why did I have
repeatedly.
to sit here for that? Where I could have just went to my cell and had it delivered. We had this
Mr.
at the end of last night before you called recess.
I'm not going to
We
debate
had a
that
whole
topic with
we
you
had a whole
further.
conversation about
Mr. Brooks, you
me
are
bringing up about the jury
defiantly
nullification.
disregarding this court. You
Here we
you
go
can
with this.
roll your eyes
Here
at me
because
all
it's,
you want.
It's ridiculous, Your Honor. You just stated that they have the power to nullify.
Would you
any
like,
law,
if you would like,
but then
I
I
will
said-
read this to you, sir, the part of the case that's important, but you're not letting me get a word in edgewise. I'm trying my best not to remove you to the other courtroom, but that is oftentimes what I need to do in order for this court to make a full record without you interrupting me. But you need to be fully aware that you may not raise the issue of jury nullification in front of this jury. It is not an allowable argument or an advisement or making them aware. However you want to describe that, sir, whatever verbiage you want to put in front of it, you may not do so. And this court has the power and the authority to limit what you say to this jury, even in a closing argument. And if you're telling me through your conduct, through your words, that you are going to disregard that direction, you will forfeit your right to present a closing argument.
Under what lawful law?
Under State versus Anthony.
It doesn't refer to that.
State versus Anthony
it
may
does-
not have dealt with
It hasn't dealt with
the
closing
right
arguments.
to a closing argument, sir, but the reasoning
You just said it right there.
nonetheless is
No.
fully applicable.
No, you
because the more
can't change
general
the law, Your
principle-
Honor. You can't change the law. That's
I'm not
practicing law
changing
from
the
the
law,
bench.
sir, but the general
I
principle.
know you used to be in legislation, but you can't practice law from the bench.
Sir, I'm
You
not
can't do that.
practicing law from the bench.
You are. If you're changing, Your Honor,
I'm not
you're
making-
attempting to make a separate case pertain to something here that doesn't even pertain to it. It has nothing to do with a closing argument. Nothing that you just
So,
named. Not
Mr.
Illinois
Brooks,
versus
I would
Allen.
like to make a record. Would you please show the courtesy and respect? for
I
me
will,
to
Your
do
Honor.
that?
I will.
All right. So looking at the Anthony case, all right, and that case starting at head note 7, paragraph 54 says the following, and you need to let me get all the way through it. We have recognized 2 distinct ways in which a defendant may give up his rights, waiver and forfeiture. State versus Pino is the first citation that they reference. Waiver is the intentional relinquishment or abandonment of a known right. Multiple citations there. I won't repeat them all. Waiver typically applies to those rights so important to the administration of a fair trial that mere inaction on the part of a litigant is not sufficient to demonstrate that a party intended to forego that right. State versus Soto. Forfeiture, on the other hand, often involves the failure to make the timely assertion of a right. That's a cite to the Dina case and Olano. Rights that are subject to forfeiture are typically those whose relinquishment will not necessarily deprive a party of a fair trial and whose protection is best left to the immediacy of the trial, such as when a party fails to raise an evidentiary objection. However, there is a second aspect of forfeiture. doing something incompatible with the assertion of a right. State versus Vaughn, 2012 Wisconsin Appellate 129, citing Illinois versus Allen, 397 U.S. 337. They went on, the court, that is the Wisconsin Supreme Court in Anthony. As previously noted, we have held that the right to testify is subject to waiver, not forfeiture, insofar as a defendant's inaction in asserting the right is concerned. We now conclude that the right to testify may, in appropriate cases, be subject to forfeiture where conduct incompatible with the assertion of the right is at issue. They go on to discuss Allen, which was not a right to testify, but was a right to be present. And I am utilizing the guidance from Illinois versus Allen and State versus Anthony. It directly guides this court that a defendant may forfeit a right by conduct by doing something incompatible with the assertion of a right. In this particular case,
all for the record.
you are very clearly telling me you are going to disregard what I told you about notifying the jury about nullification. You have absolutely no right to raise that in front of the jury. It is improper. And unless you're willing to tell me you will honor
she has to do
this ruling of mine,
right
and you will forfeit your right to present a closing argument. That is my ruling.
Guys,
I
she
object
has
to that ruling, Your Honor.
She has to do this in case she has to strip him of his right to close.
Object
She
to
has
that
to lay
ruling.
it out.
Are you willing to make a closing argument, sir, that does not reference jury nullification?
I'm going to inform the jury of their power. Again, I never stated that I was
I don't know why he
making a
doesn't
new
just lie and
jury
say yes.
instruction. I never
What an
stated anything like that. And every
Not hearing people
case
lie to
law that
court,
you just
but
stated made no
let's be real.
reference to closing arguments. It was all pertaining to being present for the proceedings of trial and for testifying.
Sir,
Not
what I'm
one time
telling
did
you,
hold on, I let Your Honor, with all due respect, I'll let you make your record. I didn't interrupt you.
go ahead.
No.
Not one case law that you just cited made any reference whatsoever to a closing argument. Not one. So how is me merely informing the jury of the power and the rights that they have? How is that a forfeiture of being able to give a
It
closing
is not a
argument?
right. It's the independent power of a
Well,
jury.
in
which
addition
is
to the
different.
cases I've just cited, sir, I'd also point you to State versus Bajirkis, 163 Wisconsin 2nd at
Well, that's a
549.
lot of-
That's
that's
a
a
Court
lot
of
of
Appeals
cases,
case
Your
from
Honor.
1991. That is the first published appellate decision in Wisconsin to consider directly several issues relating
Wisconsin.
to the jury nullification issue. In that particular case, the court very clearly said that the defense counsel in that case was allowed to talk in terms of fairness in general terms, but
Support the White Claw Fund, guys.
not to go further, and could not argue that the jury, quote, should disregard the instructions and the law and find her not guilty because it seems fair. That's a description of jury nullification. To use the words jury nullification would run afoul even more. And so I am telling you that given my inherent authority in controlling the mode and order of this court to ensure courtesy, decorum, and civility, and to ensure that this jury is presented with arguments that are proper under the law, I am hereby telling you I am in creating a rule for your closing argument that you may not raise the issue of jury nullification in any way.
Your Honor, hold up now.
Oh, he just did the.
I'm the only one that has to be made rules for closing arguments, but not the prosecution. How is that fair? How
Because
is
they're
that
not
balanced?
dickheads and they follow the
Mr.
rules.
Brooks, I'm squarely faced with your defiance regarding the issue of jury nullification
It's
that
not
is
defiance.
requiring
It's not
me
defiance.
to address this issue and to tell you very
Your Honor,
expressly
I
that that is the
vehemently-
rule
I
for
vehemently
your
object to
closing
that.
argument.
Vehemently object to that.
Your objection is noted for the record. But
May
my
I ask
rule
for a legal
nonetheless
reconsideration of your
stands.
ruling?
That request is
Reconsider
denied.
the ruling. What's that going to
May
do?
I respectfully ask for, matter of fact, I reject that ruling and take exception to that ruling.
I'll have to try that next week.
Your
For the
My
record, may I
apologies,
request a legal or factual basis for your ruling? Not one pertaining to
YouTube. Uh-huh.
being present in the courtroom or testifying. One that specifically talks about a
Hold
closing
up.
argument.
all of those requests are noted. I will not reconsider. I've put my findings and my reasoning on the record, and I stand by that record.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law?
No.
Denied.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter?
I'm not the forum for which an appeal would be sought, sir.
You have to go
Well,
file that appeal like
You
right
referred to
now.
it before.
No, she hasn't. It's not
You
her
would
job.
need to
Now I'm
direct your
confused.
appeal to
I'm
a-
confused, Your
To
Honor,
a court of
because-
appeals, not this court.
No, this is, I'm supposed to be in this admiralty court because you haven't,
Admiralty
you haven't,
court.
is the, if we're under Article 3,
I
we
actually
should
am
be in
surprised.
common law
surprised
court.
as well.
That hasn't even been addressed. If we're in a common law court or an admiralty court.
It's an admiralty court. You're
That's
going to
a
get the
baseless
firing
argument,
squad.
sir. I don't even need
And
to
what law and
address it.
fact? Based on what law and fact?
It's meritless.
Based on what law and fact?
Sir, I intend to bring this jury out and give you
I'm
An
informed.
opportunity-
I'm informed of that.
to present a closing argument.
Yeah,
If
but
you
you're also-
violate,
you're
please let
also-
me,
but
sir,
listen,
you're
you just
interrupting
made
me
a
yet
rule.
again.
You just tried to put me under a rule that no one else was put under.
Yes, we
The
all have to
circumstances
abide by those
require that I
rules.
implement this rule, sir, given your
The
stubborn
circumstances
defiance
don't,
on
Your
the
Honor. That's
issue
a
of jury
prejudice to my
nullification.
defense.
I-
You can't
you-
place me under certain rules and not place the prosecution under the same rules.
Because
Sir, the
we're not-
it has to be
circumstances of
fair.
this
Do this,
case
Darrell.
and your insistence on arguing jury nullification has resulted
I
in this
haven't-
court creating this
I haven't
rule.
argued it. I
Yes,
said
you
that I
have.
wanted to inform the jury of their power. I never once said
There's a reason
I'm
why the
going to make an
prosecutor hasn't
argument.
had to
I'm
do
going to
it.
give them a jury instruction.
You may not
never
advise
said
them
that.
or make them aware in any way that they have the power
And why not?
jury
Why can't they be
nullification,
informed of their power?
because it would violate the Bajorkis decision, sir.
Violate what decision?
But jerk.
All right, sir, I am going to bring the jury out.
And I'm going to inform them that they have the power.
And if you do that, I will dismiss the jury and I will declare that your right to present
You
a
can't do
closing
that.
argument
Under what
has
lawful
been
law?
forfeited based upon
And I make a
how I've
I'll
outlined
make
that
a oral
to
motion
date.
for a
I'm
legal
not going to
finding of
declare
fact.
that at this point because I want to see what you will do. But if you raise the issue of jury nullification, I will immediately dismiss the jury. You will forfeit your right
You can't
to
do that.
present a closing
Under what
argument.
lawful law
Watch,
can you?
watch her
And then
do
if you
that.
continue to
Under
interrupt
what
me,
lawful law?
you will be removed to the other courtroom as I
So I'm
complete
being
the
held in contempt
instructions.
again. Is
You're
it
not being
civil
held
or
in
criminal?
contempt.
All right. Go ahead.
I apologize. May I ask the court to consider perhaps an alternative, and I fully respect the ruling the court
No,
has
you
just
can't let
made,
him-
and
you
I
can't let him
understand the
do it.
basis for it.
No.
We all know the
You
defendant
established
in
a
his
precedent.
petulance will say jury nullification in the first 3 seconds the jury's in the room.
Objection
The-
to that.
Proper,
I don't
thing
think
to
that
do,
I
I
should be
think,
talked
Your
down
Honor.
Stop
to.
interrupting,
I don't
Attorney
think I
Hocker,
should be
please.
talked down to.
Because you are
allow him to
petulant.
make his closing arguments. I will object if he misstates the law. You can instruct the jury to disregard any misstatements of the law. And we continue in that fashion, if possible, for a reasonable amount of time. And if it becomes to the point where there's no reasonable, legal, credible argument that's being made, then the court can decide as to whether or not he's forfeited his right to a closing argument. But we could at least try to, by merely objecting and the court telling the jury to disregard and instructing Mr. Brooks to move on to the next topic, we could try to allow him his opportunity to provide a closing argument. If that's unworkable, then I think this record will be very clear as to the efforts of this court. And I think there is materials in the bench book, or I'm sorry, the jury instruction 705 that talk about a jury instruction. This court could even give, telling the jury that they are not at liberty to disregard the law, but we're not going that far yet because, frankly,
pull up everybody
you have
and you
told
pull
them
up.
and you will tell them that closing arguments are not evidence. And I think they will abide by that. So I know it's going to require effort for the court to allow this to allow Mr. Brooks to try and proceed, but I think we should try that or something similar to that in an effort to
Walk
get
the
through
plank,
this
Mr. Brooks.
next step, or else we will continue at this pace forever.
I'm certainly willing to try that.
It's about all we could come up with, Your Honor.
I mean, I'm certainly willing to try it in this courtroom, and then if
I don't
he
think they should
disregards
indulge me.
that, to excuse the jury, and then have him present from the other courtroom would be the second step, and then third would be a forfeiture.
Your Honor, I object to that.
Your objection is noted for the record. That will be the course of action that this court takes. The first time you violate the rule, you may be subject to forfeiting your right to be present, where you will give the closing argument from the other courtroom. And if
Thank
you
you for the
continue
participation,
in
guys.
a blatant
Please give me a
disregard
like as
of
well.
the requirement that you not reference in any way jury nullification, I may make that final determination outside the presence of the jury.
I object to that, Your Honor.
All right, with that, let's bring the jury
For the
out.
record, may I respectfully request the legal reconsideration of your ruling?
Nobody, Darrell,
Is that a tacit agreement that you don't have to answer my objection, Your Honor?
dude, it never works. I don't even ask for those because it never
I
works.
decline to reconsider.
Judge, please reconsider the thing you just shot down.
I reject that ruling and take exception to that ruling, Your Honor.
Noted for the record.
For the record, may I request a legal or factual basis for your ruling, Your Honor?
Denied.
Okay, Dad, here's the thing.
For the record, may I respectfully request a written judicial finding of facts
Let
and
the appeals
conclusion of law on this issue, Your Honor?
Makes a determination how much
For the record, may I respectfully
is
move
enough.
for interlocutory declaratory appeal on this matter?
you don't know until
the court to
they
address
tell
it.
you if you've done it.
For the record, may I move to stay
So
these
she's
proceedings
erring on
until
the
this
side of
instant
caution.
matter is adjudicated by a court of competent jurisdiction, which this court has no subject matter jurisdiction
Denied.
under,
But
The jury
based
is
on
coming
what
in.
law or
All
fact?
eyes for the jury, please.
That-
Based on what law or fact?
Action.
Because I'm going to inform the jury of their power. They deserve to know.
The power. That power, boy. Oh no. Oh no. No, no. Oh no, 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 no. Just like the TikTok.
Thank you,
meme.
everyone. Please be seated.
Or in a second, we'll get to go, oh no, it's broken.
Go ahead, Mr. Brooks, your closing argument, please.
Uh-oh, here we go. Drum roll, guys.
Good afternoon. It's been a long day. First off, I'd just like to start by letting you guys know that
He's going to do it.
it's a lot of information that you guys should be privy to, I believe.
Uh-oh, here we go.
And
His tie's really long.
one thing that I believe that
Way too
you
long.
have not been privy to is the truth of your rights and your duties. Being the jury, the fact that you and you alone have the power, not well-prepared DAs with well-prepared and clearly rehearsed speeches and exhibits and a lot of theatrics.
You could have done all that too.
Frankly, not the judge. You and you alone have the power. You and you alone decide what is truth and what isn't truth. You should be informed that you have the
Look at
power
that lady. Sue is mad.
to nullify any law that you don't agree with.
Oh, he did it.
Move to strike the statement.
Sustain.
Objection.
I will strike from the record the last statement made by the defendant. The jury
Which
will
is-
disregard it.
Which is clearly what I've been saying. I believe that not only is it fair, but it's essential that you be privy to all knowledge, not knowledge that certain people feel that you should hear and shouldn't hear, disguised under the color of law. The fact of the matter is, just like I did with my opening statements, I don't have a well-prepared or rehearsed speech.
We can tell.
I didn't look in the mirror and say certain points to myself over and over again to make sure I have them right or anything like that. I've chosen to speak from the heart in my opening statements, and now I'm going to speak from the heart.
So let's get to it. Let's get to the money shot.
What you won't hear me do is argue facts. And the reason you won't hear me argue facts is because I believe that it takes away from what should be recognized. The tragedy of this event, it should be recognized. Trying to argue facts of this, facts of that, I'm not going to waste your time doing that. It's a little emotional. I apologize for the long pause. It's hard to keep everything together emotionally. And honestly, I don't believe that I have any more tears left. It's been a hard year. For the families, mostly. And that should not be lost on anyone. It shouldn't be taken away. I said it before and I'll say it again. It's a lot of people that are healing, that are attempting to heal. That opens the door to talk about forgiveness for a little bit.
No healing from you, Darrell.
With every healing process, there comes a forgiving process.
Yes. Forgive me for the murders. Just let it all go, guys.
It's not an easy thing for anyone. What you've been hearing from the prosecution, and not to take anything away from them, but let's call it what it is. You've been hearing a lot of rerun. Same things over and over and over. No different than when you turn on the radio and you first hear that song that you don't like when you first hear it, but they play it so much that eventually you start saying it, the words to yourself before you even realize it. And then you sit and you go, I hate that song. Why am I singing?
Is he talking about his own music?
That's what's been happening. Rerun over and over and over and over and over and over and over. attempting to make things stick in your head that simply aren't true. Why do I say, what am I saying?
He speaks out of the side of his mouth. That's just a mannerism.
I say, look at the testimony. You know, the thing from the prosecution here
Just
has
his
been
mannerisms.
intent. We all know what's been said. We all know the picture that's been painted. Even the prosecution said themselves. How can you look in somebody's head and say, this is what they intended to do? You know, for a year, I've sat and gone through this. Feeling so powerless. You know, letting other people run with the narratives. Sitting back helpless while other people paint a picture that has zero truth. Zero. I understand about healing myself, tragedy, pain, all that. A lot of it, there's no need to get into. I myself in my own life have had to do a lot of healing. As a man with children myself. I find it hard to believe that anyone who's really had conversations with me, spent time around me, would think for 1 second that this is an intentional act.
Please explain how this is not intentional. Out of the side of your mouth, how is this not intentional?
I've never
I don't
heard
know.
of someone intentionally trying to hurt someone while attempting to blow their horn.
I don't know. Well,
While attempting to alert people of their presence.
yes, beep, beep, get out of my way or I'll kill you.
Which brings me to more information that
Another claw, guys. We're going to need it.
I believe that you should have been privy to.
Let's get in these claws.
And I'm sure that the prosecution will
Digging deep
beg
into
to
the claw
differ.
form this week.
But the fact of the matter is, the vehicle in question, make and model of 2010, Ford Escape.
The Escape.
The vehicle in question,
Good car. Good year.
actually 2008, 2009, and 2010 of that model was in fact recalled.
Yes.
Objection, statement of the facts, facts not in evidence.
Was in
Improper
fact-
argument, Your Honor.
Sustained.
Was in fact recalled.
Objection. Fact not in
Was
evidence.
in fact a class action lawsuit against Ford
Objection.
for those
facts not in
model
evidence,
for
Your
those
Honor.
model vehicles.
Sustained. The jury will disregard.
Information that you should have been privy to, that you weren't allowed to be privy to. Why? I don't know. That information, malfunctioning throttle bodies,
Mr. Brooks, move on.
It's information that you should have been privy to.
Throttled body.
Vehicles that malfunction and accelerate not being able to be stopped.
Objection, that is.
It's
completely
information.
inaccurate,
It's
Your Honor.
There's an
information.
objection. Hold on. Go ahead.
Move to strike statements by
Sorry
Mr.
for the
Brooks.
interruption.
They are facts, not an evidence, Your Honor, and it's complete misstatement.
Sustained.
How's it a misstatement when I have the information?
You don't have
Mr.
the
Brooks, move
information.
on.
This is information that I feel like you needed to know. You should have known. Information that was taken away from you.
Was taken
Why?
from
To
you?
prove a case?
How was it taken?
Information that you definitely should have been privy to. DA says the defendant has an utter disregard for human life. Utter disregard for human life.
Do I look like a cow with udders? Is what he's going to say next.
Not realizing that they're talking about someone that has children.
So what?
Talking about someone that watched their children come out of the womb and be born into this world, cut their umbilical cord, held them before their mom even did. Moments that I'll never forget. And yet they say disregard, utter disregard for human life.
Then why did you stop? Why did you keep driving? You should explain that. They're showing
They
up.
made reference to a rage.
Uh-oh. Oh,
As
no.
if they were, or if
Come on, don't do this to me. Don't
this
you do
particular DA was right there, standing right there. As if this DA is a psychiatrist. I say to myself, with rage, what do you mean rage? How can you characterize that? How can you have the audacity
Lee in the middle's like, can you believe this bullshit?
to diagnose what someone's brain is? Where it's at, what it's thinking, why it thinks the way it does.
Call it a random guess, Darrell.
DA makes references to blocks of no one being injured, but then says it's intentional. You add that up with the supposed rage, the supposed intent to harm and kill, and it doesn't kick in until well within blocks.
Yes, you can establish intent within a second. The thought
And maybe
alone.
it's just me, but I would think if I was characterizing someone with this intent to kill and this rage and this anger.
Don't say this. Don't say this. This is not going to come out well. You're not going to say this well. Don't say it. Don't say it. No.
Then why weren't people immediately harmed?
No, that doesn't work.
Why was someone with intent to kill and rage try to alert people of their presence, repeatedly honk their horn? You heard a detective if you recall, testified that the vehicle that he observed was not only honking his horn, but was not speeding.
Then why'd you
So
keep
where does
running
this
over
rage kick
people?
in? Where does this insatiable intent to kill kick in? It speaks as someone who's known someone for years. Which brings me back to the vehicle. What if the vehicle couldn't stop because of the malfunction?
Objection, fact, not in evidence.
What if the driver of the vehicle was unable to stop the vehicle? Because of that
No
fact,
gas, no brakes.
driver may have panicked.
You panicked?
Does that make the driver a crazed, or not crazed, a rage? Does that make the driver in a rage and intent on killing people?
It kind of looks like it, yeah. Because you intentionally sought out groups of people to slow you down. Yes, Nikki, Nikki, what if John Denver was driving?
DA played exhibit 17. You don't see anyone struck in that vehicle. On that exhibit, you don't see anyone struck. With someone who had this intent to kill, this rage, as she says. If that was their intent, wouldn't they have taken the opportunity to hit as many people as they could? Target people, mow down people. Reference was made to this vehicle, the damage. Says this was all caused by bodies, but then later turns around and says hits barricades and other objects. I've heard testimony about hearing loud crashes and things of that nature, but the DA wants you to believe that this all came from people. Evidence doesn't support that. So I go back to trying to wrap my head around everything that's happened in the last year. Praying for those families, praying for the people that tragically lost their life, because that should not be lost either. The fact that there was lives lost and all the emphasis has been put on the alleged defendant.
Oh, yes, you're the altruistic one here.
People have been disregarded.
Yes, the victims have been not given their fair due.
Makes me wonder, does the DA even care about those people?
Yes, Darrell Brooks, the champion of the people. The defender of Waukesha. Oh my God, she wants to stab him with a fucking pen. Look at that woman.
There's been prayers going up every day.
Wow, this is some sociopathic shit right here.
It's been suffering on both sides. It's been threats, hate mail.
That happens when you tend to kill a shitload of people as a terrorist.
Because of the narratives that's been put out there. The misconceptions that have been put out there. the lies that have been put out there. Lies that have caused my children not to be able to go to school.
Aw. You know, so they didn't go to school? The kids you ran over, you asshole.
For my mother to have to leave her home and stay at a hotel because she's afraid for her safety. Because she gets
Womp womp.
hate mail shoved through her mailbox.
Oh, well.
My nieces and nephews to fear for their safety.
And this means not guilty or what? I'm confused.
And what's been equally hard.
Fair assessment, Luke. Fair assessment.
It's not only having to answer the questions from my daughter, who was 7 at the time, my baby girl, who was 7 at the time, is now 8. Attempting to answer her questions that she's asking and still continue to shield her from what she sees, what she hears.
This is awful.
Having a newborn son
Who will be blessed you're not in his life.
that I haven't even been able to meet.
Which is good.
Haven't been able to hold, touch, kiss. Having to navigate everything that comes with this whole situation.
This whole situation happens at a hotel.
While still attempting to wrap my head around it. I can't honestly say how many times I've sat in my cell, especially during lights out, alone, where it's just you. And just been praying and asking myself, how could this happen?
Yeah, this is
Not
like
just for
the
the
absolutely
people.
worst way.
But for everybody involved, the community too. How could this happen? How?
Now you're dragging the community in like it's their fault?
The hardest questions you can ask is those that don't have an answer.
I'm pretty sure, like I said, I'm pro defense attorney, guys, but we got the answer to this one. You just don't want to accept the answer, Darrell.
No matter how much thinking you do, no matter how much you try to
It's because you're not thinking hard enough.
look at it from different perspectives and listen to other outside perspectives and listen to people that you trust and that you love. Still coming up with nothing. But to think for 1 second, one question I never had to ask
You never had to ask yourself?
was if this was intentional. That's something that I never asked once
Really?
because I know it wasn't.
Are you sure about that? A little sussy here, Darrell. A little sussy. A little bit.
As a matter of fact, it never even crossed my mind to even attempt to ask myself that because I know it wasn't.
Yes, because I'm so smart. I know me. I 931 people watching, guys. Thank you. Please like, Smash
And I
that
know
like button.
sometimes during this trial probably doesn't show. Maybe hard to believe.
Very hard to believe. Very hard to believe.
But trust me when I say no one outside of the families that had to go through this, no one's heart is more in pieces than mine.
Oh no. It's hard out here for a homicidal maniac. You guys just don't get to struggle. You know. You guys think it's hard?
So
seeing
again,
your
I go
family
back
die?
to all
It's hard
these
killing these
exhibits.
people.
Go back to everything that's been shown, everything that's been testified to. Everything you've heard
I'll chug one, not shotgun one.
during
That
this whole
hurt.
process, this trial. And again, I say the same thing that I said earlier. Same thing I said in
Y'all don't know what it's like to murder
opening
people.
statements.
It's hard work. It's tough work.
I'm not reading from any paper, any books.
We can tell.
Everything you've heard in opening statements, everything you're hearing now is from right here.
I don't think there's anything in there.
Everything. You have the decision. You and you alone.
Oh, I'm sure
All
they
of
know
you.
their decision.
You have the decision. I'm sure you've taken a lot of notes during this process. Some days are longer than others. A lot of movement in and out of the courtroom for various reasons.
Don't highlight that shit, man. Come on. Fucking rookie. Very true, and Tucker.
Remember the power that you have.
Oh, I'm sure they're not going to forget it, Darrell.
Don't for 1 second let it be taken away from you.
$50, Gene.
I can never understand the position of sitting on a jury in something of this magnitude. So I'm sure there's a lot of pressure. I pray that the right decision is made. The right decision.
I don't think you're ready for the right decision, buddy. Just my professional experience here. Peeking through. Yeah, the jury's got this under control, Darrell. Don't worry.
It's almost like that that message.
Good evening, Aiden.
Well, not message, but that writing. When we're in our vehicles and we have that rearview mirror and it said things are closer than they appear. But it's also another way of saying sometimes things aren't as they appear.
So they threw themselves into your car. Is that what you're trying to say? Like those old ladies tried to like clog up your drivetrain with their skulls?
I can't speak for anyone else, but me, myself, I believe in Jesus Christ. That's how I was raised. That's what I believe in. None of us are perfect. But I try every day to make sure that I acknowledge him. That's why every time I step in this courtroom, I have my Bible with me everywhere I go. I even read it on breaks, recesses. This is not something that started at the beginning of this incident. This is something that has been instilled in me since I came out of the womb. This is how my family lives their life. This is how we was raised.
If he's really going to claim that he's a sincere believer in Jesus, I'm not going to mock him for it then.
For whatever mistakes that I myself have made in my life, I've made peace with God. Made peace. I'm happy to say that my conscience is clear. And because I believe, I trust him with my life. Nobody will never know why it was his will for this to happen.
Okay, yeah, you lost the plot here. This was not Dea's vault as you crushed people off
A
your
lot of
bumper.
lives were changed that day, mine included.
I'm sure you and God are going to have a clarification meeting when you finally die. Because you don't
God's
get
way
it.
is not our own. And no matter how much sometimes we want to question, we have to have faith.
Squaring your way, map.
Look inside yourself. Look inside yourself and make the right decision.
There's a homicidal maniac in all of us. Is that what he's getting at? Oh God, you're not selling this well, man.
Look inside your heart.
Okay.
You have everything in your hands now.
They have the right to rebuttal.
Everything.
Everything? Everything!
It was right.
And scene. What can I say? Your mom buys
It
them
was right.
a lot.
Don't let the smoke and mirrors take away your power. Don't let the theatrics take away your power. Each and every one of you has a decision. It was right. Make the right decision. It's hard to think about. My younger kids getting older and at some point having to explain everything to them.
Yeah, that is going to be an awkward conversation, buddy.
Kids don't stay kids forever.
Well, the one you killed's going to stay 8 forever. So,
And nowadays, kids is frankly a lot smarter than we were when we was kids. I'll tell you that much.
so your kids probably already know you're a fucking lunatic. Just guessing.
I got a letter the other day. My youngest daughter.
Your 7-year-old didn't write you a letter. The bus
She's
didn't
still
clap.
learning cursive right now, so
Oh,
she's
yeah.
the best writer when it comes to cursive. She'd rather print.
7-year-olds don't learn cursive, bro.
She said, Dad, and this is from the letter. She said, Dad, why are people saying all these mean things about you?
Because you're a piece of shit.
I haven't read the rest of that letter yet. The rest of that sentence said, that's not the dad I know. Throughout this year, I've been called a lot of things. And to be fair, I am a lot of things. A murderer is not one of them.
Are you sure about that?
Never has been, never will be.
Are you really sure about that? Daddy, why is
So
there a
before I
plaintiff?
close my statements,
You can call me a pedophile, a child pimp, and a woman beater, but I am not a murderer.
I just want to say open your hearts. Go inside yourself when making this decision. Have no fear.
Oh, I think you're terrified of going away for all day and all night, brother. You are shitting your pants. You are terrified.
And do what you know is right.
You don't want the people Waukesha to do what is right.
What you know is right.
You're not going to like this then. You're recommending the wrong thing in your sale, man. Your pitch has got the wrong sell.
Think about everything you've heard. Think about everything you haven't been privileged to hear. Think about the whole entire picture.
They've seen the whole entire picture. It's not good, man. They got to look at your picture in the garage of the sheriff's office. Yes, there's no box for it to hide behind.
And above everything, whatever you decide, make sure you yourself can live with it.
I don't think that's going to be a problem.
Make sure you can live with it.
Can you live with it? Can you? I don't think you can, man.
That's the magnitude of the power that you have.
Well, you're in for a big surprise, Hermano. Just saying. Because
Just like this tissue is in my hand, this is everything. You have everything.
and in prison you're going to get
Be
wadded
at
up
peace
like a
with what you
tissue.
decide. Had no regrets.
Oh, don't say that. Never say no regrets. Never, 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 never. No.
Don't let this decision weigh on you after it's over.
That's not a good thing to tell the jury either. You don't want them
Hopefully
to
we
think
got a
this.
long lot of living ahead of us,
They all do. You don't.
Lord willing.
I mean, you got like a
Don't look back and kick yourself in the behind.
I don't think that's going to be a problem. I really don't. I really, really don't.
It's been about 3 weeks with you. And it took a lot of courage and a lot of guts to pause your life for this. To put important things on hold.
Doesn't take much courage.
Basically, stop your life.
You're a rabid dog. They're putting you down.
You should be
It's not
commended for being
courageous.
able to sit up here with this amount of pressure.
There's no pressure, Darrell. This is pretty easy. This is like
I
playing
want
T-ball.
you guys to know that's not lost on me. I'm sure it's a lot.
I'm sure many of them enjoy the fact
You all
that they're
should
going
be
to put you
commended
away.
because it took courage to do this. I don't know, but I would bet a lot of people wouldn't want to be sitting in your position right now.
I bet the 140,000 people in this county would join a raffle.
You guys
to
had the
convict
guts
you.
to do it.
The people in this county would pay money to take the chance to convict you, Darrell.
Thank you for that. Thank you for taking pretty much a month and setting it to the side for this.
Julie, exactly. A lot of
I
people
know it's
should
probably not proper, but you guys deserve a round of applause if you could get one.
The community will give them a round of applause upon your conviction. Don't worry. You got to worry about you, Darrell. There's a lot you got to worry about right now. Not them.
Thank you guys sincerely. And I know and I have faith and I trust that you guys know what's right. Ladies and gentlemen, I don't think it's fair to just say guys, but
Oh, very, very, very PC for 2022. But what about they, thems, and the NBs and the otherkins? Darrell, you left out
I
an
believe in your
entire.
heart you know what's right.
You left out the trans community, brother. You're gonna have to go to prison for that now.
Thank you.
I don't know how many closing arguments you guys have ever seen.
Before I give the
was-
state an opportunity to present rebuttal, please stand for a minute. So please stand.
Guys, if you've never seen a closing argument before, we're gonna right here. I wish I had a camera crew or like a producer who could like tighten up on me, but like I want you to tighten up on me. Like right now. Tighten up. Like right here. That was really fucking bad. Like, oh my God. If you ever have to defend yourself, or God forbid you ever have to provide a closing argument,
All right, have a seat, please.
do the
And
opposite
Attorney
of what
Ackroyd
he just did.
did time both
Do the opposite.
closings. You have 13:28 left.
Oh my God, she is going to
Thank you, Judge. I don't think that
whip
would
out
be-
her dick and fuck him raw. Just get ready. This is going to be bad. Here we go, Sue.
Folks, let me just say this. Mr. Brooks stands here and professes to speak to you from his heart. He plays on your sympathy. He talks about his children. He talks about the hardships that he's encountered and his family's encountered. And he brushes over the loss to the community. He wants to talk about how he's never held his newborn son. Never once acknowledges the Sorensen family, the Owen family,
Mhm.
Duran
I can't do
family.
this.
the Hospital family, the Kulik family, Sparks family.
Mm-hmm.
Never once. It's nice that Mr. Brooks can get letters from his loved ones.
Mm-hmm.
I don't know why he did this. I told you that. But actions define a person. It's that simple. You can stand with the Bible in your hands all day long and profess to be the finest man under God that you can be. But when you drive through a parade route and roll over children with band instruments to the extent that your vehicle heaves up and down, your intent is known, Mr. Brooks. It doesn't have to be guessed. It's known. You don't have to stand and wonder as he claims to. For him to keep going after he drove over those children in the band and have Jackson Sparks fly off the front hood of his car, lifeless, and keep going. And have Jane Kulik fly off the hood of his car, run her over, and keep going. I'm not going to go on. You get it. You need to look in the mirror, Mr. Brooks. If you want to accuse me of practicing my closing argument,
Okay, I object
you
here.
need to look in the mirror, sir. Your
Objection.
actions are that of a murderer. You murdered these 6 people. You endangered the safety of 61 others. There are 68 victims in this case, folks. That's not an accident. That's not a, gee, I woke up one day and don't know how I found myself in this position. If you have some explaining to do to your children, Mr. Brooks, I recommend you do it.
God damn, that was short. That was, yeah, I think he has right.
Now,
to
members of the jury, the duties of the parties and the court have been performed. The case has been argued by the parties. The court has instructed you regarding the rules of law, which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and as upright citizens to render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. The following 76 forms of verdict will be submitted to you concerning the charges against the defendant, Darrell E. Brooks. Count 1. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 1 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 1 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count 2. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 2 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 2 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count 3. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 3 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 3 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count 4. Excuse me. Count four, one reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 4 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 4 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count 5. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 5 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 5 of the information.
Really, thank you for being a member.
You find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon?
Jews prayed harder to part the Red Sea, Darrell.
Count 6.
You can't do it.
One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 6 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 6 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count 7. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 7 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 7 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 8. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 8 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 8 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 9. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 9 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 9 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 10. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 10 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 10 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 11. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 11 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks,
eyeing that jury hard.
First-degree recklessly endangering
Rich,
safety.
thank you for staying up late. I appreciate it, brother.
If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 12. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 12 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 12 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 13. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 13 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 13 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 14. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 14 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety
Yes, this
as
is a
charged in
preview,
count
guys.
14 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 15. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 15 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 15 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 16. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 16 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 16 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 17. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 17 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 17 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 18. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 18 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 18 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 19. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 19 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 19 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 20. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 20 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 20 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety
guys,
while
this is
using a
just
dangerous
awful.
weapon? Count 21.
Let's go.
One reading,
Come on.
we, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 21 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 21 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 22, one reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 22 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 22 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly
Okay, we're gonna
endangering
make it
safety
easy.
while using a dangerous weapon? Count 23. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 23 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly
I think I'm
endangering
going to play
safety
squad in the
as charged in
meantime.
count 23 of the information. If you find the defendant
Random
guilty of
assault
first
and
degree
secure on your
recklessly endangering
Hrivka
safety,
with the
answer the
tanks.
following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 24. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 24 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety
I
as
don't get
charged
why
in
he's
count
so quiet
24 of
now.
the information. If
He's
you find the
doing
defendant
great.
guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon?
Did we
Count
get 10?
25.
Oh,
One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 25 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 25 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 26. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 26 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 26 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 27. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 27 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks,
Beautiful
guilty
TK.
of first degree recklessly endangering safety as charged in count
100%
27
beautiful.
of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 28. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 28 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 28 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 29. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 29 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 29 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 30. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 30 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 30 of the information.
real quick.
If you
okay.
find the
We get a lot
defendant
of
guilty
memes
of first
afterwards.
degree
Hang tight.
recklessly endangering
This will
safety,
be good.
answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 31. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 31 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 31 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 32. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 33 of the information. That should be 32. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 32 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon?
Yes, he did.
We're going to have you take a short stand break while I confer with Madam Clerk.
Oh my God, how much more can you do? Holy Christ on a cracker.
This is 32.
Oh God.
So,
Typo.
I'm
Just
sure
bring
you
up the
have
clerk.
this will need to be corrected.
So it's a typo, which that happens in jury instructions,
Okay.
no matter how serious the case.
Twice, and then I'll make another one.
Darrell. No God here, Darrell. He's not coming to save you. As much as I'd like to mock you, or I said I wouldn't mock you for it, your understanding of how your religion, your faith works makes me think it is a crutch. You are lying. So I'm not going to ban people for bagging on you. We got a lot of super chats, though, or super chats and other comments to get through. Miss Dinga Dinga, my neck, my back, lick my pussy and my crack.
When you're ready, have
there
a
ain't
seat.
much nothing to it. Just start and do it, do it. And you roll your tongue from the crack
Count 33.
to the front.
One
Then you-
reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 33 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 33 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 34. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 34 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 34 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 35.
I thought you were
One
going to do
reading,
super chat.
we, the
Shane.
jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 35 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 35 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 36. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 36 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 36 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 37, one reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 37 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 37 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 38, one reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 38 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 38 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 39, one reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 39 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 39 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 40, one reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 40 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 40 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 41, one reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 41 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 41 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no.
Very true.
Did the defendant
Not
commit
like I said, not the message
first
you want to
degree
convey.
recklessly endangering safety while using a dangerous weapon? Count 42. One reading, we the jury find the defendant, Darrell E. Brooks, not
There's
guilty
more Bible to
of
read,
first
Darrell.
degree
Get
recklessly
started on it,
endangering safety
brother.
is charged in count 42 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 42 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 43.
He looks defeated.
One reading,
Very
we,
defeated.
the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 43 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 43 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 44. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 41 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 44 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 45. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 45 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 45 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 46, one reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 46 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 46 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 47. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 47 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 47 of the information.
That's a
If you
forlorn
find the
man.
defendant guilty of first
Forlorn
degree
man.
recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 48. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 48 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 48 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 49. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 49 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 49 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 50. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 50 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 50 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count
We'll address
51.
this.
One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 51 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 51 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 52. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 52 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 52 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 53. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 53 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 53 of the information. If you find the defendant guilty of first degree recklessly endangering safety, Answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 54. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 54 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 54 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 55. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 55 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 55 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 55 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? I think I'll give my jurors one more stand break before I conclude. So please stand, and anyone else in the courtroom, please.
You can add them to this. Yep.
And here's, if you want these, too. For now. That's more.
Oh, yeah, I did. We did all those.
Oh, did it? Yeah. All right, thank you. Have a seat.
We're in the home
Count
stretch,
56.
everybody.
One reading,
Home
we the
stretch.
jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 56 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 56 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 57. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 57 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 57 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 58. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 58 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 58 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 59. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 59 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 59 of the information. If you find the defendant guilty of first
I
degree
wish.
recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 60. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 60 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 60 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 61. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 61 of the information.
Very
Another
likely.
reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 61 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 62. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 62 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 62 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 63. One reading, we the jury find the defendant,
I'll always
Darrell
beat
E.
you,
Brooks,
sheeple.
not guilty of first degree recklessly endangering safety as charged in count 63 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 63 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 64. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 64 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 64 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 65. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 65 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 65 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 66. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 66 of the information. I'll just repeat count 66. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 66 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 66 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 67. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 67 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 67 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 68. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of hit and run as charged in count 68 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 68 of the information. If you find the defendant guilty of hit and run, answer the following question, yes or no. Did the accident cause death to Virginia Sorensen? Count 69. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of hit and run as charged in count 69 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 69 of the information. If you find the defendant guilty of hit and run, answer the following question, yes or no. Did the accident cause death to Leanna Owen? Count 70. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of hit and run as charged in count 70 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 70 of the information. If you find the defendant guilty of hit and run, answer the following question, yes or no. Did the
All right, guys, hold on. We're going to scramble. We got to scramble here. Hold on. I hate to do this, but we're going to go long crime.
information? If you find the defendant guilty of hit and run, answer the following question, yes or no. Did the accident cause death to Wilhelm Hospital?
Sorry, meme.
Count 73. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of hit and run as charged in count 73 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 73 of the information. If you find the defendant guilty of hit and run, answer the following question, yes or no. Did the accident cause death to Jackson Sparks? Count 74. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of bail jumping as charged in count 74 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of bail jumping as charged in count 74 of the information. Count 75. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of bail jumping as charged in count 75 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of bail jumping as charged, in count 75 of the information. Count 76. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of battery as charged in count 76 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of battery as charged in count 76 of the information. It is for you to determine whether the defendant is guilty or not guilty of each of the offenses charged. You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other count. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by a written note. If you have questions, the court will talk with the parties before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdicts will be read into the record in open court. The court may ask each of you if you agree with the verdicts. Before I swear the officers, we will determine the alternates.
Oh yeah, we
and
have to
then
pick the
I will
jury.
have all of the civilian bailiffs and deputy bailiffs that will be in charge of the jury.
909
during their
watching, guys.
deliberation
Thank you
and
very much.
sequestration.
I appreciate it. Guys, please click the like button if you don't mind. I would appreciate that. Let's drive the algorithm up. Let's take over from Long Crime and get its 100,000 viewers. Now, the way to pick, and this is something I'll mention,
I have a lot of stuff up here.
when it comes to picking.
There we go.
Ooh, that was loud.
Did I count at 15?
When it comes to picking alternate jurors, courts have their all kinds of ways to do it.
So we have placed each
God, that's
one of
loud.
your numbers in the tumbler. I'm going to draw 3 numbers. Those numbers will be the alternates, who will nonetheless be sequestered in the event we would need to call upon one of you to replace another juror. The first number that I'm pulling out is 10.
Yep.
The second number I am pulling out
It's like the lottery.
is 30.
10, 30, the daily pick 3 for Wisconsin.
And the third number I am pulling out is 1.
10, 30, and 1. Those are
I
your
want to confirm that I still have 12. I know Madam Clerk did it, but I will also do that to be sure.
10, 30, and 1. Those are your Waukesha daily pick 3. Here on 90611, The Axe. Waukesha's home for hard rock. Now, this is something, guys, courts have a lot of discretion how they pick alternates. I've seen where they pick numbers out of a hat. I've seen judges who they take a deck of cards and they sort it down to what they need, and that determines your lot. There's all kinds of things. Like they throw a couple of jokers in with the deck, and whoever draws the joker is the alternate. So it all depends. Judges
And I
have their
just
ways of
confirmed
picking.
that the other 12 numbers were in there.
Some judges, when they seat the panel, when they seat the jury, the 12 that are in the jury box are the jury, and then you pick your alternates.
All right, then I will need all of the deputies and civilian bailiffs to come up and be sworn on the record
So,
for the sequestration and
oh my God, yes. So the bailiffs have to be there to guard the jurors, but you have every right as a judge to kind of set up how you want to pick your juries. Some of them, the first 12 in the box are the jury, the next 3 are alternates, and there's no question about it. So sometimes it can be very creative, sometimes it can be very creative,
just in case you're
sometimes it's very boring. It depends on your judge. Ozzy's Gamer says a White Claw drinking contest. No.
All right, would you
I'd be the only
please
juror
raise
left.
your right hand? Do you swear that you will keep all jurors on this trial together in some private and convenient place, and that you will not allow any person to speak to them or you speak to them yourself, except to ask whether they have agreed on their verdict, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God. All right, and then Madam Clerk will just make a record of who you all are. It will take us a moment just to have all the finalized paperwork to go back with the jury. I do have all of the verdict forms, if I want to give that to Jen.
Corn Pop says, I'm in love. Ooh, yeah. Nice eyes.
That should have all the new ones in them. If you wanted to, it should. It does.
All right, and here are the jury instructions as well.
So they get a copy of jury
The
instructions
record
with
is
them.
6:24. All rise for the jury as they're excused to begin their deliberations.
Beginning of the end, Darrell. The beginning of the end for you. Oh. Raise that subject matter jurisdiction one more time. Come on, man. Get lippy one more time. You know you need to. You desire it. You demand it. You hunger for it.
But yeah, I'm gonna need all of them and then I'll
Yeah, no,
save
I
them
know.
down and all
But
that.
those are the-
Yeah.
Is that closed?
Is it
All right.
closed?
Thank you. You may be seated.
Oh, okay.
Just so the record is clear, the alternates, of course, will not be participating in the deliberations. They will be in a separate jury deliberation room.
Oh, put your security blanket
And
back
will only
on,
be called
Darrell.
upon if
You little
needed,
bitch.
of course, after consultation with the parties.
Little wussy.
As far as how late I will
Bye,
let them
baby Jello.
deliberate tonight, we have ordered dinner for them. I believe it will be here shortly. And I really will leave it up to them as to how late they want to deliberate before they would want a break and then to retire for the evening. They are under a sequestration order, so they will be kept separate and apart. Their electronics have been confiscated, and they will not be going home until verdicts have been reached or they are discharged from the court.
Ooh,
whichever
never
would
going
occur
home.
Sooner.
Never going home.
Anything else the parties would want me to address at this moment from the state?
Thank you, Judge.
Anything from you, sir?
Yep.
Oh, here we go. Get it out, brother. One last time.
So essentially, I'm gonna have to stay here while they're delivering. I'm gonna be able to go back to my unit, use the phone, shower.
Oh, wow. You're not even worried about
It
jurisdiction
is
anymore?
shower day for my pod. We only get 2 shower days.
I don't.
No
So here's
jurisdiction?
what could happen though,
No
sir.
jurisdiction.
I don't have a problem with you doing that, but they could have questions. And then you would need to become available so we could address any questions. They may ask for exhibits, things of that nature. So as long as you're willing to come back for those things, I don't have an issue if, I probably should talk to the COs or at least the sheriff and make sure I'm not stepping on their toes since they're in charge of all of that. But it's possible that we get a request for exhibits, some exhibits initially I wouldn't be surprised if we
rapper.
got that. So let me do this. Let me confer with the sheriff's department. I don't initially see an issue with that, but I want to make sure that they have a protocol in place and that's what they would like to do as well. Okay,
And one more thing.
go ahead.
I was curious.
What?
61 charges for the reckless.
It's too late for this, man. What the
61 injured parties did not testify.
hell? You don't have to.
So how does that work?
You don't have to have them testify.
Essentially, how are charges able to be charged if all of the injured parties did not testify?
Because somebody else can testify to the people you hit.
From my perspective, sir, the state presented their theory of the case and there was sufficient evidence regarding the charges to go forward to the jury. I can't further explain it from there because that would require me to explain the law. And I guess that's all I can really say about it at this point.
I got a point though.
I'm sorry?
I got a point though.
No, you don't have a point. You have no fucking
I'm not going
point.
to comment on that, sir.
That's absolutely not a fucking
Um,
point. You completely
Of course,
fucking
the state
failed.
bears the burden
you
of
still
proof.
don't know shit, Darrell.
And they have to
Did I
convince
have
a
a
jury
point?
beyond a reasonable doubt.
Do I have a point?
For better or for worse, sir, I was not presented with any motions to dismiss, either at the end of the state's case or
Yup.
the close of the
You
evidence,
started acting like a
regarding
crybaby
any
bitch.
legal arguments you may have had regarding those
Good
issues.
job.
Um,
You
and
waived
so
it.
at this point, the jury has the case. And
Yeah,
they
it's
will
too late now,
determine their verdicts. If there are issues of law that you want to raise after the verdicts are received,
You dumb
then
motherfucker.
you'll have to make that determination.
Yeah, that has to be raised
Dumb
because
motherfucker, it's too
essentially
late.
you can't. If no injured party testifies, then there shouldn't be a charge.
That's not
I
how this
disagree with
works.
that characterization, sir, but there is frankly no motion
all
in
how this
front of
works.
me based in law or fact. So for me to comment any further would require me to give an advisory opinion, which I'm not willing to do.
So you're saying I need to make a motion?
So what I will say at this point is I do have one issue that I would like to raise with the parties. I frankly I need a break a little bit. I mean, obviously the court has to stay open. I know my dinner is coming. And I think it's reasonable. I need to put a few things together, but I do need to make a record of some information that I received earlier today, so that the parties are advised of that. But I will do that. Let me confer with the sheriff's department about your requests. I'd like to take in about 30 minutes, address the issues that I need to address, or the issue. And I want to find out if that would interfere with your request about taking a shower and all of that. So if you can hold tight and stay with us for a little bit, that would be great. And I'll confer with the sheriff's department and have a more definitive answer for you shortly, okay?
Can I get my filings?
They aren't going to do
you want
shit for
the-
you, Darrell.
You want the original.
They are worthless, like
Madam
your
Clerk has
life.
scanned them all in and they're uploaded, I don't have an issue giving you the originals back. They will have the date stamp. They don't have a time because they were filed in court.
When he put the time on them. I also, so that you knew they were in there, printed them after I scanned them in, so it has a document number.
So you're getting 2 copies. So you'll have that, okay?
See, I didn't interrupt you. See,
Are you fucking
sorry?
serious?
I said,
That's how
see,
you
I
end
didn't
this?
interrupt you.
Thank
That's
you,
how
I
you're ending
appreciate
this?
that.
You
Really?
really?
Unless I would like the parties back in about a half an hour.
I didn't
Thank you,
interrupt you
unless
now?
they have a question sooner.
Fucking idiot. Oh my God.
Your
Oh my
Honor,
God.
do I have to go in that holding cell or do I get to go?
Oh my God. That's how you're going to fucking end this? What an absolute cringe of a human being. What an absolute cringe of a human being. Okay, we're done with this now. We're not hunting U-boats anymore. Oh my God. Absolutely horrible. Holy Jesus Christ on a cracker. Yeah, he's looking for an attaboy. And he's got the mind of a child. Yes. So this issue of, and we'll get to this right now. Do you need the victims specifically to come in and testify that they're injured? No. Other people can. So like the band director, she knew all the people in her band, all her kids, and what happened to all of them. And they were hit by the car. Reckless injury. There, boom, done. The priest who came in, talk about the Catholic community of Waukesha. Boom, done. The lady for the dance team. Boom, done. The lady in charge of dancing grannies. Boom, done. You've met all the groups. You've met all the requirements of people who were injured and hurt. That's why they had all those names highlighted. So, yes, OU8812 is, are the dead not coming to testify? Yeah. So let's get back through some of the stuff. K Mill says, ask Griner about that. Yeah. Well, that's why you don't take drugs to foreign countries unless you're an idiot. Truck Golfer says, the most outrageous crime you knew they were guilty of that you got them off of. I will decline to answer this because that could identify that person, and I don't think that's fair to them. So, respectfully, I will not answer that question. I appreciate it, though. Free Flyer 1978 for $20. Thank you so much for the super chat. Criminal courts are not weighed in favor of defendants. People without economic means are almost pushed into pleas, even when innocent, because the costs surrounding bail and defense. 100%. No lies detected. Not at all. Having defended indigent people as a court-appointed attorney, but also previously as a public defender, I 100% agree with that statement. Jarrett Petrin saying, can someone explain his fascination with subject matter jurisdiction? If a court lacks subject matter jurisdiction, it cannot try your case. Like, it stops. So that's their nonsensical obsession with it. It's traditionally from a civil standpoint, but that's why they love it. The coolest dad ever says the jury has all the power. Yes, the jury is independent. It can do whatever it wants. But they're instructed and they're told in their oaths they must follow the rules and the law. But a jury could nullify the law, and there's nothing you can do about it. Lord Browning for $5 says, does he think the jury is on his side and is eager to nullify if someone tells him they can? Yeah, because he's an idiot. But yes, 100%. A common lawyer says, I mean, jury nullification is a thing, but this is pretty standard by courts. Also, this jury isn't going to nullify. Yeah, but he's trying to save his own ass. Desperately grabbing for straws. Sojourney, Tracy says, why not the death penalty? Wisconsin has not had capital punishment since 1853. So it's been a very long time. They had a botched hanging way back when, and they got rid of it. Vince Clortho for $2 says, bound and gagged is option number 1 in Illinois v. Allen. Yes, it is. And I think that today, given technology that's available, this actually would be unconstitutional. This isn't 1970 anymore. So I think this would be a change in the law if it came before a court. But yes, currently it's still valid law. Ashley Casey says for $1.99 super sticker. Thank you. Coleman Sweeney says, just keel haul him if he thinks this is Admiralty Court. Yes, that would be hilarious. Deep Surface for $2. Thank you. Says 100% poll participation. Impressive, great crowd. Yes. Right. Oh, we got 1,000 people here, guys. Please like and give me a like if you like what's going on. Yes, Pete Wiener says, what's in the bottle, Sue? Ashley Casey for $1.99 super sticker. Thank you. Corn Pop for $1.99. Thank you. Dragon Sassoon for $2. Thank you with the super sticker. Josie, it's me, 81 says, Sean, fun stream today and great commentary as always. Thanks for letting us hang out. My pleasure. Thank you for being here. Just a map nailed to the wall for $5. How deep do you think he plowed into this crowd, and will he get plowed harder in jail? Oh, certainly harder. Yeah, they'll probably, he's going to have a fun time. Popcorn for $1.99. You're a bad dude, Popcorn. Says still not. Eat what the monkeys eat for 10 Australian didgeridoos. Says, enjoying your coverage. Congrats on the growing channel. Thank you very much. I appreciate it. Atlas Knife and Tool for $5. Thank you for the super chat. Thank you for not playing ridiculous sound effects. Yeah, that ain't gonna happen here. Added sound effects are torture. Yes, it's a different level of torture. But I agree. Quan Shea for $4.99 says, guess he's the victim now. Yes, his closing, that was absolutely horrible. I'm the victim. I'm just like you guys too. We all bleed red. We've all had problems. It's so sad all around. Can't do that, man. You can't do that. Not at all. It ain't gonna work. Levi the Welder for $4.99 says, when can they prove I had rage and the intention to kill? Well, I'd say it's a safe guess. It would be in between victims 20 through 30. Yes. And I think the DA is correct. if you had any question about his intent, once he completely ran over half the band and he didn't stop, and then he finally killed that 8-year-old boy, bounced him off the hood. Why didn't he stop? Because he wasn't hanging out with the cops saying, hey, the car wouldn't stop. He was giving bullshit stories about, a guy in a brown Kia or something like that. Lord Browning for $2 says, textbook narcissist, everyone is to blame but him. Very true. Matt for $7.99 in Australian didgeridoos or dollaridoos. Says, what happens to the third-party intervener after Darrell is sentenced? Thanks for the coverage. Well, he's going to help Darrell probably file an appeal. Just a map nailed to the wall for $50. Thank you so much. Says, please shotgun a beer so I don't have to end my life. Well, we tried that before, but when you shotgun one of these bad boys, one of these White Claws, by the way, I don't ever recommend it. This is like just sucking down pure carbonation. Ooh, you're going to feel like you're going to die. So don't do it. Shell Perk for $4.99 with a super sticker. Thank you so much. I appreciate it. MK Ultra victim for $1.99 says, is that a clawful claw, Your Honor? Naked Lunch for $9.99 says, Jesus said, go forward, my son. Take your mother's SUV. Run over as many grannies, children, men of the cloth, and young dancing kids. For I am your savior. Kathy says burp. I needed to. Mr. Mojo Ryzen 241 says, it's time to wrap this up. Yeah. A while ago. Corn Pop for $1.99 says banned. Dwayne Mantle says, why you always lying? Oh my God, stop fucking lying. Moo Gaming says, the poor guy was on his way to pick up his Uber client and these people trying to attempt suicide in front of his car. It's a travesty that he's on trial. I'm glad you see it his way. That takes some honesty. The Metalhead Martyr for $6.66. How does that Justin Timberlake song go again? Oh, yeah. Cry me a river. Cry me a river. And he did try to cry a river. Walter Malone for $5 says, no regrets, clean conscience. Jesus wanted it to happen. Worst closing ever. Just about, yes. Only God knows why this happened. Like, that's not how you do this, man. That is not how you do this. I mean, I am not Johnny Cochran or F. Lee Bailey, but I can tell you that's not how you do this. That is not how you want to do this. Rough. All right. But yeah, worst closing ever. Mr. Squiggles for $5. Did he use any powerful Bible verses? I'm sure he would have since he knows the Bible so well. Yeah. I was waiting for that too. Or he would just refer to a verse number, but he didn't. A little disappointed, Darrell. Just a Map for $5 says, you are dancing around the issue of extreme White Claw drinking, Sean. I think if you were watching earlier and now that I come down from my buzz, I think you'd understand that's a fake news story. Good sir. Just a Map again for $5 says, the length of jury deliberation will be directly proportional to how well the hotel minibar is stocked. Very, very real possibility. Julie F's new member. Thank you, Julie. I appreciate the support. Doug Gibson for $1.99. Did his mother end up testifying? No. She was a no-show. Yolanda Edwards for $9.99. Thank you so much. Says, thank you for your commentary. Well, you're very welcome. MDOH says, Sean, thank you for having a good balance of Mike and volume and commentary. I've had to leave 3 streams throughout the day because others couldn't figure out the sweet spot. Thank you for somebody who's kind of doing this by the seat of their pants. I appreciate the compliment. David Romero says, what happens to all that evidence? All those exhibits, the sweaters, all the tangible items, pictures, maps, all the things that are admitted in evidence, go back with the jury. There's only 2 times where that generally doesn't happen. If there's drugs, generally courts don't like jurors just having drugs on their own without supervision. So they may have to come back out and look at it under supervision from jail or courthouse security, or weapons, and particularly guns. If there's guns involved, they'll have to ask to come see the gun and somebody will show them the gun. And they'll come out and look at it, but they'll look at it with the defense attorney, everybody around, and the prosecutor, everybody around. They don't generally let jurors have guns on their own. Now, some courts may let you, but not common enough. Aiden Higgins says, can't say this loud enough. Sue Opper and her team at the DA's office deserve some kind of national recognition. Okay, I appreciate where you're going with that, but I'm going to go that far because they're still prosecutors at the end of the day. They did a really good job today, but that doesn't mean they aren't. Could be worse other places. But yes, I will give them credit for today. And you, Sean, for all your coverage. Well, I appreciate that part. Thank you, Aiden. And I hope it's like 1 o'clock there, almost 2 o'clock there. Thank you for sticking around. Just a Map for $5 says, there are some laws when drinking clause. Don't be a bigger beta than your boy Darrell. Slam it. Let your past relationship with him go. Well, I think I did a good job on that. Axios says, I tuned in right as she was saying, we, the jury, find the defendant guilty, and was like, wow, that was quick. Vince Clortho for $2 says, he's screwing my life right now. Stop this now, God. WrestlerTown for $5 says, remember, jury, Darrell informed you during his closing that you had the power to check yes on every box without giving any really consideration at all or having any qualms about it. Yes, it's not good to tell the jury this isn't going to weigh on you and make your decision free with a clear mind regardless of what you do. Yeah, that was Pootie Ting says, can a court appeal be denied? If you say you're going to appeal to like you want to file an interlocutory appeal, that court can't stop you, but the appeals court might say we're not going to listen to it. But you have the right to file for an appeal. The problem is when you're representing yourself, you can't just run out in the hallway and do it. If you had a team of attorneys, one of them can run out in the hallway or to an office, fill out the paperwork, get it filed, and then come in and say, we filed the appeal. But Darrell can't do that, and also Darrell's an idiot, so there's a reason why that hasn't happened. Mr. Squiggles for $2 says, Sean sat on the remote again. You know, I'm not going to take the fall for your mom anymore. If she sits on the remote, she's going to have to own it. Corn Pop for $1.99 says, I'm in love. Eric Rollins for $2 says, objection, the maid Kia was tan. It was. And Free Flyer 1978 for $10 says, visual proof, the witness can verify who was standing where, the medical records proving injuries, plus his state is the accuser in this instant, and he's facing the state. Yes. And like I said, the band teachers and leaders of those groups can verify who in their groups was injured. And they did a very good job at showing that. A very clean case and a very clean closing argument. All right. So Billy Bob for $10 says, who had better tears, Brooks or Hurd? Lamal, great coverage, my man. Brooks had better tears, I think. Brooks had better tears. At least I think so. So that is it So what's going to happen here? The jury has the decision whether or not they're going to work tonight. They're getting dinner, and they have the right to eat dinner without working. They cannot be forced to work through dinner, and we'll find out what happens from there. So they might get on it tonight, or they might want to stop now, but they could decide to go late if they wanted to. So before we go, guys, I know there's a bunch of you here. I thought we could look at some memes as well. There have been some really good ones the past couple of days. That'd be worth sharing. Yes, common sense SUV reform. We do need it right now. Oh. This one, I believe, came from Nick's page or Nick's locals, but it's a great Dr. Brooks by the great Dr. Brooks. The fort in the court. No girls allowed. Grounds. Fair as day. Fair to say. Tacket agreements. Yes. Did the fort in the court, did it get to the Lorax? He hit the Lorax with a subpoena, I heard. Landholders says they're discussing this while eating. They could be. They could also agree to say we're not talking about it. We can talk about the Brewers or the Packers. It's up to them how they do it as long as they vote as a group. And when they deliberate, they have to deliberate as an entire group. Long crimes still seem to be streaming. Yeah, well, I think they know it's going to come back quick. I think we might get a verdict tonight. I think at most 2.5 hours. So we will, here's the Darrell Brooks spectrum here. The lawful goods, the neutrals, and the evils. Oh, and it's funny because they were almost all on the same day. They filmed them as reactions. Yes, and the next one is the ground dozer. What's the business? Oh, whoever photoshopped these boxes into the dents, that took a lot of work, and yes, that was an interesting thing. Oh. He's getting an arm. Look at Darrell getting an arm workout in there, guys. Man, he's gonna have some really good cardio by the time he gets to he's gonna have some really good cardio by the time he gets to prison. Just like Social Distortion said, you know. Oh, I'm prison bound. I can't do it right. I won't want to hurt them. And this is from Judge Darrell. I believe this is an issue with the not completed closed captioning. You're running, you're a pussy, your brothers are you, not it is. Yes, they didn't understand things properly. Sue, DA Opera's had it about up to here with Darrell's shit, as you can see. Got that Beretta out, just not a Glock, but just gat. Jury's back. Oh, they got questions. Okay. No way they have a verdict. There's no way there's a verdict. They couldn't have filled out all the forms even if they... There's no way the jury's done. There's no way they're done. They have to sign all the forms, all 12 of them. I don't think they could do it that damn fast. We'll find out what that is, Christy. Logan W says the question is, he's guilty. Can we just go? Yeah, I don't know if that's going to be the case. So, we'll see. We shall see what's going to happen. Nothing's probably wrong. They're just having a question. They always ask questions. Jurors ask questions about all kinds of things, and you get worried about it, and it turns out it's not a big deal. And we're going to go back to see if we can get like Fox Milwaukee or something instead of Long Cuck, because I just don't like Long Cuck. Ooh, I guess they're one of the few games in town. WTMJ, let's see if they got it. Nope. I guess it's Long Cuck. Oh. Lion Cry. All right. Also, I don't understand why people donate money to Long Crime. That's just crazy. Oh, you think I just got nicked with the judges back? Oh my god. Damn it! How late am I staying up? Well, you should buy us dinner. Yeah. You guys just tricked me here. How late are we staying up for? A while, and I might be going over to Farron. She's covering the Fetterman Dr. Oz debate. I might go over there with her for a bit and then run over and do it. Truck Golfer says e-sign. Yeah, I'm sure they just did VeriSign to knock this all out. That would be hilarious if they did. All right, so let's get to I guess we'll cover these super chats real quick. Christy Graham for $5 says, Judge said she got the info she needs to address. I need to know what. We'll learn it at some point, because if she goes on the record, I think they'll cover that. Mr. Squiggles for $2 says, jury question, the wrong food order. Yeah. Yes, the wrong food order. OC says, can they get the death penalty? No. No death penalty in Wisconsin. The most he could face is life in prison without parole, meaning he would never, ever, 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 ever get out for these murders if he was found to be guilty of a murder and he used a weapon, meaning the car. So never, ever, ever. So we'll hopefully that makes that all set. We've still got some nice memes to hit up here, though. And we'll dig these memes out quick and quietly. This one's from earlier in the week. Yes. Yes, Darrell found a young Judge Mommy out in the woods. He tried grounds, but it wasn't very effective. Judge Mommy said, Judge Mommy tried a 90611, and it was critical damage. So let's get to what else we got here. Oh, these are good. Yes. He's a free man, and he's got his get out of jail free card. I mean, if he would have done that, he probably would have already been dismissed. Little did he know. Little did he know. Here's a very good one. Hey, bro, look what I wrote. Jury nullification, subject matter jurisdiction. You eat the child. Hold up. Oh no, hold up. Daryl's trying to hold up everything. Let's get through the rest of these real quick here. Share screen. Okay. The Oval Chase Dragster. It's an artifact vehicle. It's a crew 1. Tap any number of creatures you control with total power 1 or more. This vehicle becomes an artifact creature until end of turn. It'll either crash or win the race, possibly both. Oh no, some of you guys are rough out there coming up with these jokes, but they're good. Some of you guys are good at this. Silence. Instant. Your opponents can't cast spells this turn. Oh yeah, that was some great when he got big mad in front of the judge. Oh, what else we got here? Hands up, don't mute. Always good advice. Keep running through these. The face when no death penalties in your state. Which very true. Yeah, I'm sure if he's facing the death penalty, he would be probably in a different mindset. Instead of just being a big asshole the whole time. One last one, a good Pepe meme. Fort grounds, no lawyers allowed, all rights reserved. Ford recalls. Oh, yeah. This is a very funny one. Very good one, guys. I don't know who made this one, but you deserve a high five. Very funny. Oh. Fairness live now, but no debate yet. Yeah, I think I'll be going over to Joiner for a bit. And once it comes back, I will go over. But, guys, it's going to take them at least an hour to do the forums. And they're going to eat their dinner, and they're probably going to wait to eat their dinner in peace. So, I said this earlier, and I've said it on Discord. By the way, you can join the Discord. The link is below. 2.5 hours. 2.5 hours. About maybe a little less. 2 to 2.5 hours, I think it'll take. And I'm not counting the dinner in this because normally people say they want to work through dinner, but who knows if they actually do. They're asking for a competency report. I don't see anything saying that they're... Long crime's not even on. So I don't see where you're getting that from. Let's see Twitter. All right, let's see. Is there anything yet? I don't see... Yeah, guys, I don't see anything yet. And I don't hear anything yet, so... If you guys are screwing me, you're doing a great job. Everybody loves Cthulhu for £5 sterling. The King sterling. Sean, although you said life without parole, what about future presidential pardon, say 10, 20 years down the line? Could he get out then? No. The President of the United States can only pardon you for a federal crime. So if Darrell Brooks had committed this murder on a military base or in a national park, or if he had done it on an Indian reservation, or if he had done it on federal property anywhere the federal government could have tried him and convicted him, he could pardon him for that or give him clemency, any number of things that way. If he gets convicted here, the only person that can help him is the governor of Wisconsin, and probably not going to happen. But that governor would be the person in charge of that. So, yeah, that's the difference. If you're convicted under state law, your governor is the person who pardons you. If you're convicted under federal law, the president is the one who pardons you. Matt says, this boomer believes anything. I believe a lot of things. People tell me people say they like my channel and they like what I do. So yes, I believe people. Unless you're telling me I shouldn't, then I'll just go cry. So yell, stop nicking Sean. Yeah, I don't need this. Go terrorize Nick. He needs that. He's a growing young lad. Rest in peace, Britney Spears. What? What the hell? What do you mean, Britney Spears? I was about to say, I hope she's not dead. That'd be crazy. Oh, but there are some good pictures of Britney Spears out there. Holy jeez. Ooh. Oh, we're back.
Thank you. All right, it's 7:05. We're back on the record. I wanted to advise the parties that earlier today I received information from the clerk of court that she had received an email that the person sending the email had found a post on Justice for Darrell on Reddit, so it's a subreddit. I'm not familiar with how Reddit works, but and that the thread on the Justice for Darrell Reddit site was claiming to be a member of the jury pool. And I am going to provide the parties with the information that I was given this morning. It's a color copy of the attachment and the email that was sent. The email was received by the clerk of court at 9:10 a.m. Then my clerk received a notification at 9:30 a.m. that the clerk of court wanted to speak with me. You may recall this morning I stepped off the bench for a little bit of time. I read through the information that was provided to me, which was an email, and then the attachment, which is a color print off. Looks like the person took a screenshot, and that the anonymous post claimed to be a member of the jury on the case, and here are my thoughts on the trial and on this subreddit. And apparently, again, it's a subreddit called Justice for Darrell. All those Justice, the number 4, and Darrell, all no spaces. I then had contact with Captain Dussault, advised him that this should be investigated, and basically turned over the matter to law enforcement for a full investigation. At this point, or at that point, I made a determination based upon my review of the information that I would not stop what was happening in terms of the trial with the instructions to the jury and ultimately the closing arguments, and then turning the case over to the jury for deliberations. And of course, I am concerned about the integrity of these proceedings, and I will take whatever action that I deem appropriate once a full investigation is done. But at this point, there is no, I would say, credible information that this is in fact a member of the jury. But I will leave that for law enforcement to determine. And if Of course, if need be, at the conclusion of the case, when the jury reaches a verdict, I certainly will consider whether any questioning of the jurors at that point is warranted. So that's the information I wanted to provide. Again, copies of this information will be provided to the parties, and there is a full investigation underway by the Sheriff's Department. I have no further information about it at this time. I will not be the judge that will further be reviewing it in terms of any requests related to that investigation. I will simply be handling whether any requests as it relates to this case in particular. And I hope we have the copies for the parties.
Your
And
Honor,
provide those. Go ahead.
I'm making sure you was
Go ahead.
first. What is this?
All I can tell you,
I was
sir,
about to say, he
is
has no
that
fucking
there
idea what this
is
is.
apparently on the internet, on a site, or maybe it's an application, I'm not entirely sure, called Reddit. There's a subreddit that is entitled Justice for Darrell, and it was on that subreddit that someone wrote an anonymous post claiming to be one of the jurors. That, of course, would be a violation of the rules that I set up for the jurors,
Daryl's going to be so thrilled.
which is
people
why I
have to
turned
support him.
over the information to law enforcement so they could make a full and complete investigation.
For the record, I accept for value and return for value these documents. I'm confused.
He's like, how the hell can they support me? I thought I was a piece of shit.
At this point, sir, I'm providing the
He's like, I'm
information.
confused.
I trust that the parties will review it, and if a party believes that any request needs to be made of this court, then an appropriate request will be made. But at this point, I'm just advising the parties of the information that I have. And I will add this, I will, of course, it's important that the results of any investigation be turned over to the parties. I don't know how long that will take, but that is also my direction. That was really the only direction I gave to law enforcement, is that the results of the investigation that be turned over to the parties.
Was this? Oh, I'm sorry.
Go ahead.
Was this just found out about this morning?
Yes, the email that was sent to the clerk of court was received at 9:10 a.m. And then that email and the attachment, I'm aware of a second email that was sent to our clerk of court at 10:02 a.m. And I think when we stepped off the bench following the case being given to the jury, I was advised that other emails had been received throughout the court system. And I simply said, obviously, that information needs to go to law enforcement. I haven't seen it, haven't reviewed it. But any person who works in the clerk of court's office who has received an email, that email about this topic will be forwarded to the Sheriff's Department. Their forensic unit is handling the investigation, to my understanding. Attorney Upper, did you have a question or something to state?
Yes, Your Honor, I just wanted to state for the record that I have also received similar emails at my office this afternoon. They were sent not to me directly, but to the district attorney's office website. And I only wanted to
Oh my
point
God,
out
people
that
actually like
in
believe
viewing the
this.
contents of
Wow.
the posting, well, first of all the emails refer to the exact same posting and the language is the exact same in all the postings. In viewing the contents of the posting, we question the veracity of the posting because it refers to things that, quite frankly, are not true. And also, upon reviewing it, Your Honor, we came to the conclusion that it does not exhibit any material prejudice against Darrell Brooks that may affect the veracity of any verdict that may be returned in this case. The posting is largely critical of the court and to some extent the prosecution, but the nature of the posting is actually in support of Mr. Brooks. That's why it's under a subreddit called Justice for Darrell. And I don't believe there's any reasonable reading of this post that would lead someone to believe that it suggests the juror harbors substantial or material prejudice against the defendant.
Thank you. I appreciate the additional record.
Can I say something, Your Honor?
Go ahead.
I object. These people love me. The internet loves
Just
me, Your Honor.
briefly skimming through it.
This has to be true, Your Honor.
I do want to state for the record that I have no involvement with this. I'm really like shocked like this even came to light. I will say just by skimming through it,
he's going to be like, I agree.
these are definitely things that have been talked about in the court. So common sense would say that this
Exactly.
came from someone that has either
Of
been
course.
in the court to hear what goes on in the court or a jury member. There's no other way.
Well, actually,
Because
the proceedings are live streamed worldwide, Your Honor, available on YouTube worldwide, so I don't agree with that assessment.
Well, I mean, it's pretty obvious that this would come from somebody who's actually, I think it's pretty clear.
Well, I'm leaving it in the hands
Darrell's
of law
giving him an
enforcement
upvote.
to do a full and complete investigation. Again, I take the integrity of this process incredibly seriously. And if there were to be a juror who violated the rules, I would take that very seriously, and I will not hesitate to take any action that I deem appropriate. At this time, it is simply being
Darrell wants
investigated.
to
This
drop
was an
the,
anonymous
upvote on
post.
this. Give him some karma.
And if either party believes any further action needs to take place as it relates to this particular jury, then I trust they'll file the appropriate request with the court. So with that, the courtroom, oh, go ahead. I'm sorry. Something else, Attorney
A
Alpert?
different topic, Your Honor.
Oh,
if
sure. Go
possible.
ahead.
While we're all together, I just wanted to address exhibits and what the court's procedure would be. We have no objection to any exhibits going back to the jury room if they are asked for, and precluding the requirement that we all assemble every time a note comes out asking for one exhibit. So as long as we're all here and we have some time, maybe we could discuss that.
I'm willing to discuss that. Do you have any position on that, sir?
Yeah, I would object from the standpoint that I would need to see any exhibit that's being asked about and the relevancy of that exhibit being asked for. I think that's only fair.
Exhibits that have been received, a relevance objection would no longer be valid because the court has already ruled on the relevance and the admission of the exhibits. The issue is whether it goes back to the jury room. I'll give you for example. Sometimes in a trial there are medical records that
Yes.
need
it's
to be
all fine.
filed in their complete
It's all your
form
fault, Nick Ricada.
under the statute, but
You
really
and that
maybe only a
nose.
portion of it would go back to the jury. Or depending on why they were offered and whether there was any medical testimony regarding a diagnosis, for example.
No, but they could
could
ask to view it
impact
again, but that would be really
That
hard to
sometimes
set
there's
up.
privacy issues with an exhibit, if there's
There
a
would
social
probably be
security
getting
number
pictures
for
of
a
it
witness or something like
video
that.
of the
But generally
walk-around.
speaking, the exhibits have been received. And the jurors can ask to view photographs, written documents. They can even ask to view the videos. The videos would need to be done one of two ways, either which requires everyone to assemble because we do have the technology to play them directly to the jury room. But that simultaneous with that is it would be played in here. So everyone would be seeing what's being played in the jury room at the same time. So that does require the parties to be in court. That
Gotta
allows
get
the
those
jury
updates.
to continue with their deliberations, talk about what they're seeing, etc.
So can the jury see in here now?
No. I'm talking about a video. We have the ability to play it directly. There's a TV. I should have said that. probably not too, why would you know there's a TV in the jury room, right? So there's a TV monitor in the jury room that is connected to the technology in the courtroom. So whatever is playing here could be a still photograph, could be a document, could be a video. We can play in the jury room at the same time. But as far as other exhibits,
That's a pretty neat setup that they can play.
So it would be only the exhibits that's been
received.
That's pretty cool.
So
Correct.
nothing new, nothing's gonna come out of the blue and be like, "Yo, yeah, we're gonna."
Only what's been received during the trial.
No,
If it
Darrell.
would be helpful, I can have Madam Clerk give you the printout of the exhibit list that shows everything that's been received, if you would like.
That's about like 7,500.
There's a lot of exhibits,
That's a lot of exhibits.
but I'm willing to have her print it off if you would like it.
I think it'd be helpful just in case. I'm guessing at some point that will come into play.
Right. For example, they may come back and say, we'd like to see exhibit 15, which is the map, the large map of the parade route, okay? They might want to see the other map. Maybe they want to look at a video. There's a lot of exhibits, so I'm not going to speculate what they want. Sometimes they write notes to us and say they literally list out all the exhibits that they want. Other times they'll say, can we have all the exhibits? So sometimes parties do stipulate. That's what the state, I think, was trying to get at. So do you have a position on that? If the jury requests an
There's
exhibit,
extension for him.
do you want the court to rule on it individually, or do you agree that if they request an exhibit, it can be released to them?
A rule on it.
All right, fair enough. Anything else, Attorney Opper?
Yes, we had discussed yesterday, and I'm not trying to get too far ahead of myself here, but what was the time limit that the court wanted to work off of for giving notice to the parties when the verdict is available?
30 to 60 minutes.
Okay,
That's nice.
thank you.
Some of that will depend on when it is, if it's late in the evening versus during the day. And you might be wondering, how late will I let?
How late will you let them go? Oh no, come on. Come on, Jen, don't freeze up on us, honey.
That we're done for the evening. They'll come back in. I'll read them the instruction about they obviously can't deliberate when they're not here, so I'll read through that instruction to them that you can't deliberate. And they would go again where they are being sequestered, and then we would reassemble tomorrow morning if that's what is needed.
Okay, thank you.
You're welcome. Anything else from you, sir?
Did you talk to the judge, the deputies? Or
I did. Thank you for that reminder. The jail has asked that I follow the standard operating procedure, which is to have you in central holding and not up at your cell. But if need be, I'm willing to order that they give you a shower later, if that's helpful, whether it be tonight or tomorrow morning, okay? So even though you're going to stay close by, I'll make sure, I'll work with the jail to make sure that you're given that opportunity after we're done for the night, okay?
Yeah, at least let me take a shower.
So I've been
And I will
told
have
there
to-
is a question that will be coming out shortly, so don't go anywhere.
Don't choke me, Judge.
What?
I said, don't choke me.
Choke you?
Yeah, because you know what I'm about to say.
What are you about to say?
Subject matter jurisdiction. You
like
knew I was about to say that.
You act like some
Sir,
fucking joke.
I'm not going to
now.
address it. I already have. All right.
It's not fucking
There are
funny.
requests for 3 exhibit. Is that his number? I know he signed up, but I do.
It's cold.
I meant to tell them that. It's a signature. I need to know the number.
They have
to
a lot of
tell
tension.
the parties who the 4th person is, because I'm not going to say the name on the record. They have a request for 3 exhibits, 15, 5, and 55. Number 11 is the 4th person.
You said 15, 5, and
55. So I can pull,
I was gonna say I don't know. I know 15.
15 is the map.
15 is the map. Yeah.
Any objection to the map, sir?
Yeah. I want you to rule on everything.
Well, I was gonna go one by one.
It's gonna roll on everything, Jesus.
So I'll start with exhibit 15, which is the map. What's your position on that, sir?
My position is at this point, what is the relevancy of the map? I think it's been seen a million times. I know it by heart now. At least that's probably the only one I know by heart.
Well, what's the state's position?
Yes, we absolutely, there's
Of course
no
you know by
reason
heart, you
not to
drove the
send that
route.
back there, Your Honor. There's 76 counts that they need to work through and to assist them in identifying which victim is which and which group they were with and where they were on the road. Absolutely, there's no reason to hide that from them. It's helpful to them in their deliberation.
All right, I will send exhibit 15 back to the jury room. It is an exhibit. And there really is no reason not to send it back that has been identified by the parties. All right, the next exhibit is exhibit 5. That is the photograph of Erica Patterson.
Oh, I definitely object to that. Seeing as how it was supposedly 2 incidents, one of which didn't even happen, which the prosecution sent paperwork to acknowledge that it never happened. So I don't even it's too dicey with that. What incident would 5 be referring to? One of which
The
never
battery
happened,
count.
and then one. I don't even know what I'm looking at if I look at 5.
What's the state's position on 5?
Again, Judge, there's no legal basis to exclude that from the jury. There's nothing prejudicial. It's a single photograph. I should say overly prejudicial. It's a single photograph of a single person showing the injuries that are alleged to be associated with count 77. It's directly relevant to their deliberations.
There is no count 77.
Count 76. You are correct. It is count 76, not 77.
See why I'm confused?
Well, there is an amended information, and I clearly instructed the jury on 76 counts. Be that as it may, I'll find that it is proper for Exhibit 5 to go back to the jury, and that will be sent to them. Now, Exhibit 55 is a video. How long is that video?
Uh, 15 seconds.
So my inclination, and I'll hear from the parties first, and then I'll give you my inclination. So any objection to playing for the jury Exhibit 55?
What exactly is in Exhibit 55? I don't.
It's a video from Curry Insurance facing eastbound showing the grannies being struck. We could put it up if you want to preview it.
Ooh, that's not good if they're looking for that
Go ahead.
video.
And we
They're gonna
are
bury 'em.
requesting that it be viewed by the jury in their deliberation room.
What I can tell you, if I do allow it, since I would have to we'll verify that the technology is working, and then I would play it for them twice through. And we would watch it at the same time as they're viewing it. Theirs would just be in the jury room. But I'll preview it for Mr. Brooks so he can see it first. Well, the state will preview it for me. All right, your response, sir?
Yeah, I object to it.
It doesn't matter. It's still coming in.
It's in order. I guess my objection would be
Yes, because they're
it would be
watching.
hard.
and
It would
kill
be
these
hard to
people.
say why the jury would request it.
Because they want to make sure they got you to dead to rights, Darrell.
I don't know. I'll just let you rule on it. I don't particularly. There's so many videos that's kind of like the same video anyway.
Well, Exhibit 55 was received by the court. It's relevant to the charges in this case, and I will show it to the jury. I will work with Teresa and then the jury bailiff to ensure that the technology is working when it's up and running. I will play that for them twice through. This is what I have proposed to write on the note back to the jury as it relates to all three. Exhibits 15 and 5 are attached. Exhibit 55 will be played for the jury 2 times, hyphen the clip is 15 seconds. And then I will initial that and date it.
Any reason why we need to be played twice?
And I just would note that the jury foreperson wrote yesterday's date. It is the 25th. My date will be indicated. Obviously, they didn't get the case until today, so it's just a Scrivener's error on their part, putting the 24th versus the 25th. They don't have their technology with them, so I can't really fault them for that. All right.
Any
Madam
reason
Clerk,
why
if
it
you could-
needs to be played twice?
That's my practice, at least on short video clips.
So what about if they request for a long video?
Then I'll make a determination then. I find that since we have the new technology, it's easier just to do that and play it twice than to bring them out and for them to say, stop. And then can you go back and can we watch it again? Because that's my experience. So I'm really trying to avoid that. So we'll stay out here.
Darrell should be terrified right now.
And then
And Jen has the walkie.
we'll work to, they'll have to pause their deliberations so we can interrupt them and give them the exhibits and then make sure the technology is working. So if the state wants to have that ready to go.
I set for value and return for value these documents, Your Honor.
Thank you.
Do you accept for value, return for value the handcuffs when they get placed on you? That's a question I want to know.
Do you have, you know how to do that, right? We've done that before.
It's one button.
Eliza, you asked this question about why are they talking about this now with the juror. Any appearance of juror impropriety and undue influence on jurors has to be addressed as part of the record. That's a very serious allegation. And if they don't, then that's a appeal issue Darrell could bring up
Is there
down the road.
audio with this
So-
or is it just video?
If they're addressing it, it's going to get
Just video.
investigated.
Okay, thank you.
So it is very important they deal with it. Senor Spielbergo for $10. Should be like 10 pesos, though. She shouldn't have taken it seriously. Now people know all they need to do is make comments about being a juror on a forum, and the judge will be forced to bring it up in trial. Yeah, but it has to be brought up. It has to be protected. Remember, you have to protect the record. The record has to be protected at not all cost, but it has to be protected. And addressing the matter, having it investigated, protects the record. So. That is a very necessary thing that had to happen. But yes, I do love Darrell thinking, "Oh my God, people on Reddit love me." Bendover says, "Last chance to poop on the desk, Darrell." So, guys, once this part gets done, I am probably going to run over to. Actually, Gigi says, "I'm confused why it would be bad if they want to watch the video. I feel like it'd favor Darrell because wouldn't they just know their decision without having to watch it?" Yeah, but I don't know. Maybe they're trying to show that these were all intentional, also because this is the one where the officer said he drove through the crowd, turned his wheel, and then like cut across them. So as he like looked out the window behind him. Daniela says, with a chance of verdict tonight, I don't know, but it looks like they're going at it hard. So if not tonight, first thing in the morning. So, also, guys, once this is done, as far as the verdict watch tonight, I'm probably gonna wrap it up. Fair and Balance invited me to come over and watch the Pennsylvania governor's debate.
You can turn it off and
Yeah, that might be interesting, especially with the
is it off?
one candidate
All right,
being a
the video was
stroke
played
victim that has a
twice.
lot of
We'll wait and see
issues
if
and
they have any
speaks
other
like
questions.
gibberish at times. Might be
Your
interesting
Honor,
to watch.
Yes, sir.
about this Reddit, is that how you say it, Reddit?
That's my understanding.
Yes, Darrell read it.
This particular person is who the email was sent from, the person at the top of the page?
That's, do you have the email that has the 9:10 a.m.? That's my understanding, yes.
Were they identified to have any connection with the trial in any way?
I'm leaving the entire investigation in the hands of the sheriff's department. I can't answer that. I'm sure they're looking into it though, because that's a good question.
Yes, he just gave up. Fair and Balanced. Faran. Faran. Faran.
Yeah, they'll have to submit.
Balanced. So get it. Her name is Farron, so it's like play on.
All
Fair
right,
and Balanced.
I'm gonna step off. Obviously, the courtroom remains open. And we'll let you know if there are any additional questions.
Like Pooh Bear. Think.
Subject matter jurisdiction, Your Honor.
That's-
Will we be addressing it for the record?
What a fucking lunatic. It's like a joke with him. Now it's a joke with him. He lost his shit over it earlier, and now he's just a joke. So, yeah. So, guys, that is it for tonight. Yeah, coolest ever says looks like a pop tire. Yep. So, I am going to take a break for now. I'm going to go hang out with Farron over on the other channel, on her channel, covering the debate. It sounds like it should be fun. At least very much I'm taking a break. It's been almost 6 hours. I need to switch gears. If they do come back tonight with a verdict, actually I might get a hold of see who's doing stuff and talk to them. But for right now, I'm just gonna pop that in chat. Oh, Fair and Balanced. Yeah, hold on. I'll put that up. Screw it. Here's where we're going tonight, guys, and I will see you there. So everybody, thank you so much. Everybody with the likes, subscribes, the super chats, everything, all the kind words, my mods, everybody. If we have updates, though, we'll come back. So remember, till next time, guys. Party on Nick's stream. Yeah, if Nick wants to have it, we might do it there too. Yeah, this Reddit thing, it sounds like bullshit. Entirely bullshit. So, guys, remember, until next time, just because you did it doesn't mean you're guilty.